Let's kind leave, my lords. Lords, Mr. Dushyant Dave, senior advocate, is leading me. He is online to mention a matter, my lords. Mr. Dave, senior advocate, my lords. He is before your lordships online to mention a matter.
Lord, may I have liberty to mention?
Yes, Mr. Dave, yes.
Lord, there is an appeal, Lord, which we have filed, Lord, writ appeal 1725 and 1726 of 2024 against Lord Learned Single Judge's judgment of 24th September 2024. Lord, in this judgment, the learned judge, Lord, without making us party, without hearing us, has, Lord, made damning observations against us, given finding against us of what happened 25 years ago. And Lord, we are now getting caught in this political slugfest between Lord these powerful politicians. I'm a small landholder, and Lord, as a result of learned judge's judgment, I will face criminal prosecutions. So, Lord, I respectfully submit your lordships may list this appeal or appeals on Friday, because otherwise, Lord, I will have Lord serious repercussions on civil and criminal liabilities.
What is that subject matter?
Lord, this is about Lord, this fight between Lord, certain public-spirited citizens and the Honorable Chief Minister of Karnataka, in which I have nothing to do. Lord, I sold my land in 2004. 2004. Lord, it was denotified in 1998. And without making me party, 98 denotification, judge, learned single judge says is bad. My sale deed of 2004 is bad.
My lord, may I make one submission? No. 23rd. My lord, may I make one submission?
Yes.
My lord, this is that Muda matter. My lord has posted it on 23rd. A similar matter, yes.
Lord, I am respectfully submitting. My matter
Monday,
is
Mr.
entirely
Dave,
different.
Monday.
I don't want to get caught in this political
23rd,
slugfest.
Saturday.
Your lordships may keep my
The
matter
same
on
matter,
Friday.
my lord, connected.
No, it's not connected at all. You didn't make me party.
No,
Lord,
it's
your
not
lordships may
connected.
kindly
We'll see.
keep the matters on Friday, my matters.
Okay,
I have
Monday.
nothing to do with them.
Monday, Mr. Dave, Monday.
Lord, Monday your lordships may not keep them. Lord, then your lordships may keep it on Saturday when your lordships have fixed the other matters.
All right, Saturday's other matter is coming up.
Yes, your lordships have. I would have liked on Friday, tomorrow or Friday, my lord, subject to your lordship's pleasure.
If it is not inconvenient to you, Monday is better. Whatever you think. Saturday also can be kept. Monday is better.
My lord, Monday, your lordship knows is a
All right,
difficult
Saturday.
day. So, my lord,
Saturday.
Friday I
Saturday.
had kept myself free for this. I thought
Saturday. Mr. Dave, Saturday.
Saturday.
23rd.
Well,
23rd.
may I make one request, my lord? Your lordships may at least not direct that my matter be kept separate from the other matters on Monday.
Therefore, we
Because
are keeping separate.
Yes, my lord.
Anyway, we'll
Because I
keep.
don't want to get caught in their, my lord, political slugfest. I am a citizen who is suffering without any reason.
We'll see on that day. If you want Monday, then Monday, Saturday, then Saturday.
No,
Your
Saturday,
choice.
my lord. Then lordships
Yeah.
may keep it on Saturday.
Saturday.
Grateful. Deeply obliged. Both the appeals, my lords.
Subject to removal of office objections.
Yes, yes, of course, my lord. I'm sure, my lord. We don't want any office objections.
Yes.
Grateful.
Obliged.
Saturday, 23rd, your lordships.
Yes, yes.
Yes, my lord. Grateful. Deeply obliged.
My lordships, this is a fresh matter. We are moving a memo for posting, my lordships. It is a contempt case against the Commissioner, Mysore City Corporation. We filed a memo for the posting, my lordships.
It will go in December 16th.
My lordship, there is an urgency because already Honorable Single Judge has ordered regarding the issuance of the building license. And they had permitted, they had given the deadline of 1 month, but it has been 4 months, my lordship, since still they are not given the building license for the complainant, so that we are filing the contempt against the commission, my lordships.
No urgency. What is the contempt?
My lordships, Monday, my lordships.
What is the contempt?
They are not obey the order of.
What order is not obeyed?
My lordships.
What is the order which is not obeyed?
This Honorable Single Bench had ordered at 5/8, my lordships, to direct the, they have directed the accused, that is Mysore City Corporation, to issue the building license, my lordships.
Issue the
Building license.
building license?
Yes.
No. 17 December.
2023 contempt matter, madam. Roaster bench is sitting on Friday. The roaster bench is sitting on Friday is what I've been told, madam. Moving that matter.
Which row? Then need not mention you this bench.
Krishna Dixit will take. Justice Krishna Dixit is sitting on the Friday, madam.
Who?
Krishna Dikshit's bench, my lord. sitting
We
on-
do not know. Go before that bench. It can't be mentioned before this bench. Or go to the registrar judicial.
We went to the registrar, my lord. We were directed to move it before the.
It can't be mentioned before different bench.
With your,
Different matter of a different bench can be mentioned before different. bench. Yes.
With the lordship's permission, may I mention serial number 72?
72.
Yeah. These are section 37 appeals filed by the BBMP against the award holder. I appear on behalf of the award holder. I've come from Mumbai for this matter. On 13, the matter was kept at serial number 110, but it just did not reach. So your lordships are kept. There's an oral orders against us saying that we would not press the section 36 applications.
Earlier taken up.
Yes, it was on the 13th at serial number
But I represent
110.
I represent the appellant in this matter. There is a matter, my lord, where section 37 is invoked before your lordships. Lord, an undertaking is given by them saying that they will not precipitate the matter before the trial court, my lord.
It is,
One second.
yes.
In the meantime, my lord, your lordships have directed me to produce the documents showing that I have made payments.
That payment.
Yes, payment issue, my lord. This is the one, my lord, they moved it for 2:30 to be taken up.
Yes.
Your lordships on the last date, my lord, rejected that. But I don't have any, this one,
it
any
was
time
there
it
on-
can be taken up, my lord. Absolutely no problem.
In course of the day letter.
Yes,
I've come, this is just my request. I'm not, I can't press.
Yes.
I've come especially for this matter. If it was at 2:30 on the 13th also,
Second half will take up unless it reaches earlier.
no difficulty. Obliged.
Serial number. With your lordship's permission, may I please mention serial number 58? It's a PIL. Lords, I have traveled from Delhi for this matter. I understand I'm asking for too much. Lords, may please take it up after lunch if in case it does not reach.
PIL no urgency.
My lords, on last 2 days, my lords heard me. I was appearing through VC. I felt that the personal appear. I need swift 5 minutes, my lords. I would not be taking more than five
At
minutes.
11 o'clock on any day, it is too early to say that matter will not reach.
Lords, in case, that's the difficulty. I will be very obliged, my lords.
It doesn't reach, will not.
At the end of the list, my lords, at least at the end of the list.
End of the list.
I'm grateful. I'm great.
Keep at the end of,
My
at the
lords.
request of learned advocate, keep at the end of the list.
My lords, in case it reaches, I understand it's too much for me, but my lords, this,
So we are keeping at the end of the list.
uh,
At your risk and consequence.
in case it does not reach.
See, at 11, you don't mention. The other matters are
I'm-
earlier
I'm-
heard
I'm
and
obliged.
therefore.
I'm grateful.
My lord, serial number 16, 93 and 102, my lords. These are all connected matters. I'm appearing for respondent. May I request not this matter could be taken on Saturday, my lords.
Saturday not possible.
Lords, next week, my lords. The other side, I've informed the other side.
What is the,
Three
Good.
matters, my lord, arising out of same order. There are three writ appeals. I am representing in serial number 16 for appellant. Any one day it can be.
Next week, my lords, any date, lordship may fix any date.
Also, there are other matters also, my lord, because 116 also. Both, all could be heard together.
what is it about?
That is, my lord, there is an order in 10/1/2023. So by that, my lord, Tahsildar, my lord, is my lord.
Direction to Tahsildar. It's a direction to Tahsildar to implement its order.
He is written.
But next week, any day, Tuesday or Wednesday.
Next week.
Tuesday or Wednesday, lordship may fix it.
Serial number 17, my lord. Serial number 17, my lord. My senior some LTS, my lord. Adjournment, my lord.
20.
17. 17.
Delay of 62 days. There is a delay of 62 days.
Yes, my lord. My senior some LTS, my lord.
17,
Yes, my lord.
17.
Yes, my lord.
That is writ appeal number 1607 of 20.
Yes, my lord.
So what do you want?
Adjournment, my lord.
Adjournment. So there is a delay. We'll issue notice returnable on 20th January.
Issue no.
Delay of 62 days. 20th January, yes.
Serial number 66, Your Honors.
Yes, madam.
Serial number 66.
One by one. Yes, madam. 107. Oh.
Sir, ಅದು date ಆಯ್ತಾ?
107, 107.
How date 21?
12500.
Delay the notice.
Yes, what do you?
Have been disposed of.
Notice ಮಾಡಿದ್ರು ಅನ್ಸುತ್ತೆ. 17.
It is the proprietor's concern.
15 million. Oh, late, 107.
It is not a company, my lord. It is a proprietary company.
Okay.
Contempt case, it's a fresh matter, my lord. It has some, since as the single judge has been passed in order, then there is no action taken, my lord. Friday, it may be. Friday and Monday, my lord.
12th December.
Your Honor, serial number 66, Your Honor.
Yes,
I seek for adjournment, Your Honor.
refused. Yes, madam.
Your Lordship, commercial appeal of 2024, the matter is pending for admission. Notice has been issued and they have received the
So date must have been given.
no date was given, that's the reason. It's a IA for condonation of delay, the notice is already issued, but there's no date on.
13th December. 13th December.
Yes, not one matter, my lord, land acquisition
Yes,
matter, my lord.
I seek
You are
for
breaking
short
the line therefore.
Yes, ma'am.
I seek for short adjournment, Your Honor. Serial number 66, Your Honor.
60,
66.
66.
Yes.
Yes. Yes.
I seek for short adjournment.
And if there is no urgency, then in January.
Any short date, because the other side said take short date.
So others, don't worry about the other side. You are for appellant,
I'm for the respondent.
respondent. 17th December.
My lords,
Yes.
Yes, one land acquisition matter, my lord, BDS fraudulently allotted my land to the third party, my lord, even BD also admitted that, my lord, it was fraudulently admitted, my lord, fresh matter, my lord, any date this week. I am in the position of the, now they are disturbing, that is the urgency, and the single judge, my lord, rejected the ground that, my lord, a locus standi of mine, my lord.
11th December.
my lords. This is
My
a
lord.
fresh matter, my lord. Contempt.
You want to make?
Please, it's a bank's appeal that I have filed against the order of the single judge who has remanded the matter, the third round of litigation back to the DRT. Now the DRT is posted the case on the 25th, that is next Monday. So there is some urgency because it's a 22-year-old third round of litigation. The bank is fighting for recovery. And the third time after all the adjudication by the DRT in securitization appeals and other things, and this honorable court having dismissed several writ petitions, somehow there was a matter that was remanded back to the DRT. The matter is listed on 25th before the DRT. Now, if the matter is proceeded, it becomes the writ appeal almost becomes an infectious appeal.
This
It's a
Monday,
bank's appeal.
this Tuesday.
Monday it is listed
You
before.
can
DRT.
seek time there, very, yes.
My lords, this is a fresh matter.
Could I request on Saturday, could I persuade this court to post it on Saturday at least?
No, no.
This is a fresh matter, my
At least
lord.
on Monday itself.
Saturday we won't bond, we don't want to burden ourselves. Let it be a holiday.
This is a fresh matter, my
Yes,
lord. Contempt.
For us,
petition.
there is no holiday.
Contempt petition, my lord. The learned honorable single judge passed and writ of mandamus to consider the representation of the petitioner, my lord. Within 2 weeks to the Commissioner of Roads, Transport Safety, my lord, Commissioner, Bangalore, my lord. They are not obliged the order of mandamus order.
After vacation. After vacation.
My lord,
After
serial number
January,
21.
January 21, yes.
My lord, in December, my
lords.
lord, please.
No, this
My
See,
lords,
already 2 months has been.
not possible.
my lords, this is a memo that I'm filing right now to in fact reinstate, to recall a particular order, my lords, against writ. We had filed a writ appeal, 635/2023. What had happened was that it was posted on 27/6/2024 for non-compliance of office objections. And so there were three
This
particular,
for restoration, IA for restoration,
yes,
posted on
My lord, serial number 21.
11th December,
11th December.
11th December,
We have been, okay. Please,
Serial
my
number
lords.
21, seeking for a short adjournment
21.
for the appellate. I've informed the other side.
We'll go in 22nd January.
My lord,
Short date may be given for the respondent. my lord.
Short date is not.
my lord,
The
serial
withdrawal
number 10, my
application is
lord.
there, my lord. 2014, we have completed the work.
29th November.
My lord, serial number 10, my lord. I appear for the appellant in serial number 10, 6 weeks time, my lord.
Let's say for respondent number 7, please. This matter is purely covered by the decision of Honorable Supreme Court. Please, ma'am. I
That's
have proceeded
filed,
along with my memo. I have
the
also
mem-
filed memo for disposal.
The copy has not been served, my lord, to me.
It is
Which
served.
serial number 10?
10
Let
is,
I
it
appear
be
for
called out.
respondent
Don't-
number 7, please.
Let you be here when it is called out, when it is taken up. You remain present when it is taken up. We'll see what to do.
yes, ma'am.
Yes, Mr.
One PI. This case has been not posted for hearing more than 120 days back on 4th July. From then onwards, it has not come like that. 590, RP 590.
Ask him to file interim application for preponement. If date is not. So go ask him to be registered judicial, not before this bench. Yes. sir.
Lords, one PIL matter of 2021, my lord, seeking for a mandamus against state lords where they have sanctioned for construction of road. But now, my lords, I'm told, my lord, they are withdrawing that plan. My lords. I'm seeking for a mandamus. 2021 PIL not yet listed. My lord. I'm moving a memo for
They
that.
are withdrawing what?
My lords,
They are withdrawing
seeking for
what?
a mandamus to, my lords, execute the work, my lords, with respect to construction of road is concerned in a particular area in Udupi.
12th,
Sanction is also done, but they are now trying to withdraw and they have not carried out the work.
12th,
2021 PIL.
12th December.
Like
Next contempt matter, your lordship, the learned single judge has given direction for accused father to give consent for renewal of passport. The minor child is a US citizen, your lordship. For admissions and other legal formalities, she requires the passport and valid visa, your lordship. The
10th December.
May I make one more submission? Serial number 97, it has come for non-payment of PF. With respect to respondent number 5 and 5 to 7 are concerned. I've also mentioned it in cost item numbers 5 to 7 are the petitioner before the learned single judge and they're sailing with her. At my risk, I'm seeking for dispensation or to notice to them.
It is in the office objection board.
PF, not non-payment of PF, my lords. I'm seeking dispensation of notice against.
Notice is
5 to
dispensed
7.
with. Issuance of notice is dispensed with against respondent 5 and 6.
5 to 7
5 to 7 as requested by learned advocate Mr. Swans.
may be listed on.
What is that appeal?
Writ appeal.
Appeal may be listed after 10 days.
Deeply.
I want this to be listed this Friday, the bench sitting here is what I have heard. I
To
don't
go-
know, I'll ignore it.
You go before registered judicial and he will, if not before, it belongs to different bench, isn't it? It belongs to different bench.
Most honorable CJ and most honorable respected Krishna.
So it's a different bench. My brother is not Justice District.
On 28th October, I have given to judicial register.
You're mistaking my brother as Justice Dixit.
Okay, my lord. But I want this to happen. I'm
You
already 78. I
guide
have
him to
come
go to
with,
registered judicial. Then we'll see what to do. We'll see what to do.
See number 93, Mirat. I am told somebody has taken adjournment. If it's adjournment, stay has to be extended.
Serial number
93, Mirat. I was present here, I don't know.
93.
Stay has to be extended, Mirat.
So you need time.
Stay has to be extended, Mirat. I am ready. I am told somebody has moved for adjournment.
Nobody has asked for time so far.
Then it's all right.
Yes.
I will wait for.
Anybody asked for time? Who? Hmm? 27? Call out 27, we say tell or convey to Madam, it is adjourned to 27th. I'm
Stay
sorry.
nahi the extended.
Stay will be extended.
Right foot there.
Contempt matters, still number 1.
Madam.
Sundaresh HC.
Appear for a complaint in this case. Plus, there's a delay of 325 days in filing the contempt. Madam.
It was heard.
No, last occasion your lordship has directed to furnish, last occasion your lordship has directed to furnish in a recent judgment regarding delay. But no such, I do not find any new judgment, but earlier judgment, my lord,
It's only Karnataka judgment you are
yes.
giving. So find out there are judgment. We'll find out.
Please.
Wednesday, next Wednesday.
Please.
You find out. Next Wednesday, sir. Please, next.
Still number 2.
I appear for the complainant. We have given NOC in this matter. However, the client has not collected it from us, seeking for a short adjournment.
It was stated by learned advocate Mr. Ajay and Ajay.
Yes.
Ajay Jain that client have taken away the papers.
My lords?
Clients have taken away the papers.
No, they are yet to take away the papers. We have intimated them.
Be engaging another learned advocate, or they are yet to take away the papers. He wanted time, stand over to 19th December.
Still number 3. CH Maltesh.
For the petitioner. Allotment of not side to the ex-service man. His representation is not
The
considered.
notice returnable on 19th December. Please.
The PL matter, still number 4.
For the
Jamil Pasha.
petitioner. There is a direct prohibition under the rule for granting a land within the city limits. In spite of it, by order annexure a piece of open land is granted to a private society, of course, society of auto rickshaw drivers. Under annexure A, my lord. The translation is at page 53. Even the order recites that it is being used by the public for all these years and it remains an open land. As per page 54, fourth sentence, as per rule so and so, no government land in the municipality can be granted to personal or associations. This has been reserved for public purpose.
It is granted to whom?
Granted to an association of auto rickshaw drivers, a private association, according to them registered under the Societies Registration Act for building Samudaya Bhavana, etc. That is respondent number 6.
Where is that condition you are reading in annexure? Where is that condition?
Page 54, my lord, translation. It starts at page 53, 54. Fourth sentence, third sentence. The proposed land is in the limit of Batagal Town Municipal Council. As per Rule 22A2 of the Karnataka Land Grant Rules, no government land in the limit of municipality can be granted to personal or associations. This has been reserved for public purpose. But since the land is vacant and Auto Rickshaw Drivers Association is using the land, association has the intention of constructing a meeting hall for education, cultural and social development programs of the poor children and students of Batagal Taluk.
So it is a public purpose.
Public purpose in the sense, my lord, it's an open land. I can understand a government institution being built. It's not that. It's not something which is being built by municipality open to all. It's being given to an association. Specifically, rule says private association grant shall not be made to private association.
Notice returnable on, you go in January. 17th January.
Please.
So, number 5, to Somshekar case, PA.
Permit me to appear for the petition, Somshekar is on. What is the? This land belongs to the corporation. It was given to the fourth respondent for the sports purposes. Instead of that, a club is constructed for commercial gain.
It is a sports club.
Yes,
So.
No, in fact, it is the as per CDP, it is meant for parks and places, Now, I am only seeking a mandamus to implement. The government has already
Notice
taken a decision.
20th January.
Number 6, the GR Mohan.
Permission appear for the petitioner.
So you are
My
filing
lords, on
some.
the last date of hearing, on the last date of hearing, my lords had directed us, before notifying the advertising bylaws, the same should be brought to the notice of my lords. Hence, we had written to BBMP and now BBMP is placing it before my lords.
The one submission, my lord, I'm sorry, my lord. Not been notarized. My lord.
Pardon?
It has not been notarized, my lord. I'm sorry, my lord. Just now I will.
If you
Yeah,
are placing on
I'm
record,
extremely
then
sorry.
do it.
We will-
Notarize.
We'll go through it.
Notarize it.
39 euro.
We'll go through it and also give our
Next
suggestions.
Thursday.
And
Thursday.
one submission, actually. Last paragraph on 20 to 10. It is further observed and provided that if the interim, before the petition comes up for consideration on the next date of hearing, any hoarding or flex is installed and found to be endangering public life, it will open for the petition to place all, I have placed all such things on record now. Now, earlier when I pointed out, they removed it on that. It's on the majestic area, huge skywalk on that. They put, if it is falls down, it will be dangerous. Now again they have put up on the day when I mentioned on 20 to 10, they removed it all. Again they have put up now. Produce the photographs and all.
Thursday.
Now what is happening? BBMP is not aware of anything. That is the official they say.
My lord, Thursday.
Yesterday he has, yesterday.
Memo
filed on 1911. The lordship.
Yesterday he has
given
given me a copy, my lord, pertaining to a corporator, my lord. He has put up the posters. We have seen to that it has been immediately, my lord, as said in our earlier affidavit, my lord, the patrolling is going on, my lord. Incident, my lord, this will also be.
No.
FIR has already been registered against this sector.
Your lordship appoint any learned advocate as a commissioner
almost around more than 1,000, because earlier we submitted, it was not there and we made our submission recorded. Now again, after the Dasara and the facilities and Rajyotsav festivals and all things, no maximum number of hoardings have come up unauthorized illegal. In spite of this, because this bylaw, it may take some time. Now, what preventive measures they have taken, it is not because they are supposed to do night rounds and things not happening.
For the time being,
My respect.
Thursday or Friday, when?
If you largely look at the photo, how dangerous it is.
22/11/2019. The Honorable Court has passed an order that now it is only within the BBMP limit. It would be taken up for the entire state on 22/11/2019. Subsequently, your lordship on 12/8/2024 also wanted to take up the matter for the entire state. Now, lordship may kindly see, I have produced certain documents which says now the hoardings are put up. Even life-size hoardings are put up, 60/40, 60/80. It is unabated. Certain things have to be, your lordship have to extend the order of removal to the entire state. I have produced photographs.
You file this first, then we'll.
State, I have served the copy on the application. He has not served a copy on BBMP, the state. State.
Some short date may be given, your lordship. sometime.
Copy of which, what? Copy of what? Copy of what you want to say? Service of,
They have said that BBMP asked for a copy. It is outside bank BBMP. I'm going to have choose the copy of the.
we'll hear the
photograph.
matter, not today.
Because there is a local bylaws are there, other than outside BBMP.
Friday or Thursday, whenever you want. Next.
Some short date may be given. Okay.
Thursday.
Further, we'll also, short date, we will
Thursday.
respond.
Thursday and Thursday.
We'll respond to this. Okay.
This is still number 7. Okay, Anupama ji Abba.
My lords, and for the petitioner, my lords. My lords, this is the Kambala matter, my lords. On the previous date, this honorable court was pleased to permit us to implead 3 parties. Notice may have to go to the parties, my lords, respondent 4, 5, and 6.
In fact, is not gone.
They have to pay the process now. They have not
Yeah.
paid the process.
Notice has not been ordered to them, therefore there could not be a process. Impleading applications were allowed, but notice was not ordered.
Can I make one suggestion, my lord? The only grievance of my learned friends, if I have understood correctly, is, my lord, if the Kambala is held there, the animals will get affected. I've requested them to constitute a committee, my lords, to look into it and examine and report to this honorable court, my lords. Your lordship, I'm filing this memo. So that, my lords, a factual basis will be there. The translated copy is there, my lords. Formation of a committee technically study the impact of animals of Pilikula Biological Park by organizing Kambala, Festival of Kambala, so and so. The following committee has been formed to technically study and the impact on the animals of Pilikula Biological Park by organizing Kambala Festival at Pilikula Development Authority, Mangalore. So, my lords, we have taken, my lords, Chamraj Nagar Zoology Garden, Mysore Deputy Director, my lords, Department of Animal Husbandry, my lords, NITK Suratkal and Pollution Control Board. 4-member team has been constituted, my lords, to understand and give you a lordship's report. So that, my lords, ultimately the contention is, their contention is not that Kambala should not be conducted. The main prayer is entirely different, my lord. The amendment prayer is what they are seeking to put in the amended petition.
Let them serve, then we'll see. At the other side, the
So-
rest of the respondents.
Because we have given an undertaking, my lord, saying that we will not conduct the thing, my lord, till the thing matter is done.
Keep it on immediately on 3rd.
Please, my lords. Your lordship, Next week, One in- submission. we will, Last occasion I had filed an application. Due to technical errors that came to be dismissed, your lordship. There was a specific, that came to be dismissed. There was a specific observation by this honorable court that my application was not supported by an affidavit.
In lieu of that, I have filed another application which has numbered as I number 5. Just come on the roster, your lordship.
Today it is
I number 5.
impleading.
Impleading, yes, sir. The wildlife conservationist. I submitted earlier.
Will impede you. It is a
Let it be allowed.
notice to the newly added parties. Newly added parties, which were added on the last occasion as well as one added today.
My lords,
Tenable on 3rd or 4th December.
my lords, respondent number 4 is the deputy commissioner, maybe the.
My learned friend will take notice for them.
4 and 5 is the Pilukula Development Authority. If the government can take notice.
That's okay.
Who will accept?
I approve, my lord.
Learned additional government advocates, Srimati Nilo Parasper accepts notice on behalf of.
Respondent number 4, my lords, and respondent number 5.
My lords, the 5, the commissioner is there, my lords. We'll see to that they file their wakalat. my lords.
4. Commissioner, on behalf of Commissioner, who will
My lord, the government will take notice on their behalf.
notice by end delivery is permitted.
Please, my lords. For 6, we'll take out process, my lords.
I'll take
Respondent number
notice for
6 is a.
For the rest of the respondents,
Lordship, I'll
notice
take
by
notice to Kamala committee, I'll inform
end delivery is permitted.
the lordships. I will take notice for R7, the newly implemented.
You are accepting notice.
Yes, I will accept.
So for
He
number.
is the impleading applicant himself.
Your name, we accept notice for the newly completed for ASCA IA number 5 applicant. 4th.
This number 8.
78.
State in the back. Saurabh Barke.
Yesterday, my lords, the appellant's counsel had indicated that they're going to withdraw the respondent number 7 and 8 from the array of parties and file a memo.
Well, it's the last set of things. Respondent numbers 8 and 9 are private person. I indicate that if a memo for seeking dispensation of issuance of notice. I'm filing that. It's one more submission. It's when senior advocate argued on my behalf, there was some error in the translation when we were referring to the convenience compilation. That 2 documents translation also I may be permitted to place on record ballots. Court office. Dispensation.
That's it.
This matter where state wanted to allot land, my land, CSI matter.
Learned advocate for the apparent Mr. Pawan Kumar Evan, is memo dated 20th 11/24. Seeking to. No, dispensing with notice is not. You are deleting or not? Are you deleting this respondent?
It's their parties before the writ petition. I cannot.
Then we'll take up the hearing. Dispensing you don't, it is not your discretion, dispensing of notice.
It's
So keep it on now. 3rd, not 3rd. Next week, कौन सी date आएगी? 22nd, 26. 26.
It's the undertaking given by state may be extended till.
We'll deal with on that day on.
Maybe notice has to be issued to these respondents so that they are served minutes.
Oh,
He has to
not
take-
not necessary.
Please.
Its undertaking may be extended.
We'll proceed with the matter on 26th. You go on protracting the things for one reason or other.
Work
Since
has
how
come
long
to a
this is going on?
standstill. Work has come to a standstill.
So we'll
Construction
put an
work
end
is
to either
going on.
26th.
It's a apology, the
For
You said
establishment
that
of
you are
the
going to
chancery
delete, therefore we granted time. Now you are coming out with dispensation of notice. So
But-
don't be dishonest with the court.
But
You know the
definite-
distinction between dispensing the notice and deleting the respondent.
It's definitely not. Yesterday I made a submission.
No submission. We are very much aware of what you submitted.
It may be taken up tomorrow minutes. I'll delete.
By tomorrow, we'll take up on 26th.
26 minutes.
We are not yet your dictates.
I'll file an application, appropriate
We
application.
do not know whatever you want to file. We'll take up on 26th. Proceed with the matter on 26th. There's no way of do it with a legitimate prolonging. Not by dishonest mean. to
It's
prolong
definitely
it.
not, my lords. I apologize if
What else
there is
it
any
is?
confusion or miscommunication
It
from my
was
part.
argued for 3 times. You did not request any deletion. You did not request any dispensation of service. After it is argued, after it is resolved, you are coming with such request and memo.
I'll file
And when you
application.
file a memo, it's a different memo. Be straight with the court, Mr. Counsel. Otherwise, you lose the faith of the court. Yes.
Lords, I apologize for any miscommunication
Don't
from my
need
part.
any- We don't need apology from anybody. We want honesty and straightforwardness while arguing and conducting the matter. Yes, next.
Serial number 9.
The petition and the appeal, my lord, relate to
Serial number.
Press number 9.
Yes.
relate to, my lord's, issue of a lookout circular. Lords, there were 2 bank respondents, my lords, public sector banks. I am for Bank of Baroda.
You are for bank.
I am, lords, for Bank of Baroda. We are in appeal. Lord, there is one judgment, my lords, that I must bring to your lordship's notice. It's a judgment, my lords, that appears to be somewhat against me. Subsequently, my lords, the Honorable Bombay High Court,
On what ground these circulars are suspended?
lords, on the ground, my lords, that one of the grounds is that the office memorandum itself is not valid because it does not have statutory flavor. The office memorandum under which the lookout circulars are issued are themselves invalid. That is one of the grounds. My submission, my lords, before the Honorable Single Judge was that it is not in challenge. The validity of the office memoranda is not in challenge. Not the impugned order, your lordship.
Anybody appears for the original petitioner?
Appearing for respondent number 1, ma'am. The petition and for the single.
Original petitioner.
Impugned judgment, my lords, is at page 49.
You travel, you are in the country now?
No, my lords, subsequent to the learned single judge's order on 13/2/2024, I left the country, my lords. I'm currently in the United States, in Abu Dhabi.
Let us see the reasoning of the court.
Please. Lord, the judgment begins at page 49. Your lordship, my lord, may kindly come to page 55. That is where, my lords, there is a discussion with regard to in para B as to the Home Ministry's office memoranda dated so and so. Then, my lords, the consideration commences at para C, page 61.
So is the petitioner indebted to this much amount?
These lords, it's in both the banks put together, my lords, it is more than 2,500 crore. And this is the second round of litigation at the hands of the petitioner. The petitioner earlier placed a challenge.
83 crore. And 237 crores. No. Personal guarantee and personal guarantor owes respondent 3. Who is number 3? You are respondent 3.
Lords,
original respondent 3 is bank?
yes, my lords, originally respondent number 3 is me.
That is
2,324
Baroda.
crore.
Why should the court stay this lookout circular? Let us see the reason.
Please, my lords. My lord, if your lordship will please come to para C at page 61 onwards.
as to the multiple office memoranda providing for issuance of LOC. Learned senior advocate Mr. Acharya, appearing for the petitioner when questioned, submitted in his usual fairness that no formal challenge to the subject office memoranda for the issuance of LOCs has been laid in the petition. Panel counsel, appearing for the Bank of Baroda, vehemently contended that in the absence of a challenge, the court cannot venture into adjudging their validity.
Where you are reading?
Notes, para C at page 61. I'm sorry,
61.
page 61, subpara C. Not in 1 minute, my lords, may I submit? The writ petition did not question the validity of the office memoranda. The writ petition only requested for permission to travel. Therefore, my lords, one of the contentions that the bank took was the validity of the office memoranda is not a question that falls for consideration.
What was that office memorandum?
My lords, this office memoranda are, my lords, the memoranda under which lookout circulars are taken. I have produced those, my lords. In fact, in the judgment that I have just passed on, all the office memoranda, my lords, are extracted by the Bombay High Court. May I request your lordships to kindly see that, my lords. If your lordship, my lords, will please come to page, the most relevant one, my lords, your lordship will please find from page 249 onwards. If your lordship, my lords, for a moment will please come to page 233. 233 gives an index of all the office memoranda under which the power to issue a lookout circular is exercised. The first office memorandum, my lords, your lordship will please find is at page 234. It is dated October 27, 2010.
What is Mareva injunction order?
Lords, worldwide freeze of all the assets of the petitioner before the learned single judge. That order, my lords, is at page 199 of the paper book. What has happened, my lords, is
Please, my lord. My submission is this, my lord. The Honorable Apex Court, he's stayed with the matter, my lord, and issued notice on, my lord, the matter is pending before the Apex Court. My lord, it is listed on 28/2, my lord.
What is that matter before the apex?
My lord, the judgment of the Apex Court, the judgment of the Bombay High Court is totally against the Union of India and also against the bank.
So you have filed the SLP.
Union of India has filed.
Union, my lord, has filed the
Union of India has filed, my lord. It's Union of India versus Vijay Chetan Shah, my lord. So the matter is pending, my lord. It is to come up on 28/2/2025.
So you want these to be posted afterwards?
Please, my lords, the order of the Bombay High Court, my lords, the Honorable Bombay High Court, has struck down the power which grants the public sector banks to issue LOCs, my lords. So by virtue of this order, my lord, the LOCs issued by both the appellant banks are unconstitutional.
The Bombay.
Bombay High
In the
Court.
memo, my lords, that I passed, I have produced it, my lords.
Page-
Both the order of the Honorable Bombay High Court and the order of the Honorable Supreme Court. There is some sort of, my lords, although it does not say stay, if your lordship permits me, my lord, I will just read out the order of the Honorable Supreme Court, The Honorable Supreme Court says they cannot travel without permission of the High Court. Therefore, my lords, there is some sort of cloud over the continued applicability of the decision of the Honorable Bombay High Court. I have placed both, my lords. for your
Just
chips
to
can
assist your lordship, my lord, if your lordship may kindly turn to page 252 of the memo that has been filed by my learned friend. (252), my lord.
The Supreme Court order, my lords, is at 291. The first paragraph, my lords, at 291, pending consideration of these special leave petitions on interim stay, the private respondents stroke writ petitioners before the High Court shall seek permission from the High Court in the event they wish to travel abroad. Then it is needless to observe that if it is filed before the High Court is disposed of petitions, the same shall be considered and disposed of expeditiously. Pendency of these petitions would not come in the way of the petitioners herein formulating a fresh office memorandum if found necessary.
We'll keep afterward. Please, my lord, so that things are clarified.
Please.
Just to assist your lordship, if your lordship may kindly turn 252, page 252 of the memo what my learned friend produced now, my lord. It says it's on the official memorandum
Of this,
the issuance of lookout circular in respect of Indian citizen and foreign citizen. My lord, this is the order, my lord. The chairman, managing director, chief executive, and public sector banks. Lord, by virtue of this office memorandum, the LOC was issued against the petitioner, my lord. So now the Bombay High Court has ruled against the union and also against the bank. Therefore, we are on an appeal before the apex court.
where is Bombay High Court judgment?
My lord, the
Virat Chetan Shah.
please, my lords,
Yes,
the
please.
operative portion, your lordship will please find at 227. At 228, my lords, Roman para 4 is the relevant question. Is the inclusion of chairman, managing director, CEO of all public sector banks in clause so and so of the OM dated 22nd February 2021 effected by the previous amendment bad in law and liable to be struck down on the grounds of arbitrariness, unreasonableness, improper? On all these grounds and others, yes. But my lords, Roman 5, the Honorable Bombay High Court does not pronounce a finding on. Roman 5, my lords. Roman 5 is the substantive power for protecting the economic interests of the country, whether a LOC can be issued. There, my lords, the Honorable Bombay High Court says does not require to be pronounced upon. The relevant portion of Roman 5, your lordship will find at page 264. L, my lords, in exceptional cases at 264. In exceptional cases, LOCs can be issued even in such cases as may not be covered by the guidelines above, whereby departure of a person from India may be declined at the request of any of the authorities in B above. If it appears to the authority on inputs received that departure of such person is detrimental to the sovereignty or security or integrity of India, or that the same is detrimental to bilateral relations with any country, or to the strategic and or economic interests of India, if such person is allowed to leave, he may potentially indulge in act of terrorism, offense against state, departure ought not to be permitted in larger public interest at any given point of time. This was the substantive power that was relied on. Substantive power is not set aside by the Bombay High Court. Only the procedural part, who can issue the LOC, only that has been set aside.
As a matter of fact, in the previous round of litigation, the coordinate bench of this honorable court has taken the view that for the purpose of securing the economic interest, whether there will be a power to the bank, the banking institutions headed by the person who is in the helm of the affairs could issue the LOC, has already been considered in the very same matter. That judgment was passed in writ appeal number 315 of 2021. It forms a part of the writ appeal papers before your lordships. In the second,
Yes, sir.
Arvind Kumar.
Yes.
Once I'll just take your lordships to that, the relevant paragraphs. Because the coordinate bench has already dealt with this matter, my lords. Notes at page number 136 in the writ appeal papers which your lordships is having.
We are keeping this after the Supreme Court.
Very well, my lords.
This was no point in. When shall we put? 20. 8th of February.
Lordships.
Matter is coming up before the apex court on 28th,
25th.
25th February.
28th,
28th.
28th February. my lord.
A list on
Coming
28.
up on
Lordships
20.
may have this in the first week or second week of March, my lords.
10th March.
Lordships.
Great. Great.
I appear for the appellant, my lord. My lord,
Appear for
the
respondent number 7.
impugned order is
That
at
time.
Yes, my lord.
Why you wanted?
My lord, the impugned order is at page number 12, my lord. My lord, the appellant grandfather was granted the land under the Gromore Food Schemes, my lord.
You wanted time.
Yes, my lord.
On what ground you wanted time?
My lord, I need some time to go through the matter.
It's a covered by decision, please, that's. The
Now-
learned single judge has referred.
Now itself, they have
the
served the
judgment
memo for
which were
disposal
passed in the
along with the
identical
judgment.
matters at para 8 of the impugned order, please, page number 18, please, that's. I have also produced a memo for disposal along with the orders passed by the apex court.
Produced by which judgment, please, sir?
Now we have served the
Jamma.
copy, my lord.
That's,
Najamma.
yes, please, which was challenged before the Honorable Supreme Court. The SLP also came to be dismissed, please. It is observed by the learned single judge at para 8 of the impugned order, please. Page number 18.
Where is the judgment?
Page number 18, please.
80.
18 of the appeal paper book. In page number 7 of the impugned order.
He wants time. When you will argue?
Next week, my lord.
Next week, Monday. Monday. Monday will be what date? 25th.
Number 11.
Monday 2/3.
Your lordship, there is 30 days delay.
Stand over to 25th of November to be listed at 2:30. In view of the submission made by learned advocate to the respondent that the controversy, that the issue is covered by decision of this court confirmed by the Supreme. Yes, next.
Your lordship, there is 30 days delay.
Notice returnable on
Please.
22nd January. Aye.
Please kindly condone the delay and issue the notice. Issue the notice to the respondent.
Why? This is 11. 39 days not. While this writ appeal accompanies interim application for contempt delay of 39 days, which has occurred in deferring the appeal. Comma. The court had an occasion to go through and consider the judgment and order itself, which was on record. Passed by a single judge and impugned in the appeal. It could be noticed from the facts and controversy involved in the petition that while dismissing the writ petition, learned single judge has rested his decision on a very cogent ground. The challenge paragraph in the writ petition at the instance of the appellant petitioner, by appellant petitioner, was against notification published in the part 3, page numbers 769 to 779 in Mysore Gazette, dated 19th November 1963. By respondent number 3, Special Land Officer, City Improvement Trust Board, whereby the land belonging to petitioners, along with the other lands at Malalawadi village, probably Mysore Taluk, was acquired for the formation, for sought to be acquired for the formation of layout of sites connecting Jayanagar, Saraswatipuram, and Honachikopal, 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 Mysore. Further prayer was made to set aside notification dated 25th March 1969, published in the Mysore Gazette, dated 8th May 1969. Insofar as it related to the property of the petitioner. The petitioner wanted to declare the scheme of acquisition, declare the acquisition proceedings initiated by the responsible authority. Petitioner further prayed to declare the scheme of the acquisition proceedings initiated by third responsible to have lapsed. The petitioner wanted to restrain the authority from interfering with petitioner's possession, seeking declaration that it would amount to trespassing on the property of the petitioner. Evidently, the land acquisition notifications issued in the year 1969 came to be challenged. In the year 2024, the filing date petition. Another notification dated 19/11/93. Wrong. 1963. Not another ground. Full stop. Thus, the challenge to the notification was after 60 years. Delay in challenging the acquisition works fatal. To stop in any view, delay of 60 years, delay of 60 decades is too long a time, which could hardly be countenanced for its viewing leniently from any standpoint whatsoever. The land is already vested in the government upon acquisition. The award was passed on 26/7/1972. And the notified son of the notified Khatedar received the award notice on 19/9/72. Whereupon the land stood vested in the authority, free from all encumbrances. Full stop. In light of the above evident facts, in light of the above stark facts, when learned single judge dismissed the petition, the challenge to the judgment and order lacks merits. Full stop. When the appeal itself is not liable to be entertained, liable to be accepted against the judgment and order on merits as above, no purpose would be served in condoning the delay.
Your Lordship.
In that view, the application for convenience delay as well as the appeal, both stand dismissed.
Your
Because it's a
Lordship,
hard learned.
Your Lordship, please kindly humble submission.
No.
Our senior counsel G.K. Krishnamurthy will appear. Please,
60 years, nobody will hear.
please, Your Lordship, because we are in position, Your Lordship. They have not deposited the amount in the favor of appellant, please. Section 24, which is clearly tells us. Your Lordship.
Council after 60-year generations change. You challenge after 60 years.
Your Lordship, our G.K. Krishnamurthy senior counsel will be appear. I will engage him, please. Kindly pass over the matter, please, Your Lordship. This is our humble submission, please. Please, kindly, Your Lordship. Kindly pass over the matter, please. Please. Please, Your Lordship. Please, Your Lordship.
Not possible.
Your Lordship, kindly pass over, Your Lordship. Please. He will appear, sir, please. G.K. Krishnamurthy senior counsel, I will engage him.
After the conclusion of the order,
No,
you are
please. I think I
never
thought,
mentioned in the beginning.
Your Lordship, I thought, please. I thought it will.
We also say, please don't repeat the request.
Your Lordship, please kindly pass.
Let come at 2:30.
Kindly pass over, Your Lordship.
We are saying come at 2:30.
2:30. Yeah, please. Much obliged.
Take 20. All 35.
Well, happy for the appellant.
I appear for the Union of India in this matter, my lord.
Yes.
What's the?
This was earlier heard.
Yes, not for some time. Then, Lord, my learned friend wanted to withdraw, Lord, the writ appeal that they have filed. Then he filed a memo saying that, Lord, he wants to withdraw the memo, file for withdrawal of the writ appeals, which I opposed, saying that, Lord, they have already implemented, Lord, the order of the learned single judge. There is a circular that they have issued, but which circular have challenged independently by filing a separate writ petition. And Lord, having Lord said that they're going to withdraw the writ petition, the writ appeal. And Lord, can I just pass on Lord the writ petition that they had filed, the objections that they have filed Lord before the learned single judge in the second round of litigation, but where and the circular that they have issued, wherein they categorically say, Lord, we're implementing the order of the learned single judge. And Lord, initially that is why they filed a memo saying that I will withdraw their writ appeal. Now, Lord, they want to say, Lord, that I'm not going to withdraw the appeal, and they want to pursue the matter. Therefore, Lord, I objected, saying, Lord, that on one hand, Lord, they cannot say I'm implementing order of the learned single judge. And on the other hand, Lord, they cannot, Lord, say I will pursue the writ appeal. Lord's permit, I'll just pass on, Lord, those papers, Lord.
That's serial number 12. Lords, I'll undertake to represent the respondent number 2. Lords, last time, Lords had directed them to.
Proceed with your appeal now.
Very well.
I'm sorry, Lord.
Proceed with your appeal.
No, they have not yet. I have not served with the copy of the writ appeals filed. My Lords, my learned friend has filed 2 appeals. Lords, serial number 12 and 12.2. Lords, I have not been in 12. My Lords, they had sent me an email. There are around 600 pages missing in those papers. So I had asked them to give a hard copy, which I'm yet to receive. Serial number 12.2, my Lords, I have not received the copy of the appeal. So let them furnish me a copy of the appeal. I'll undertake to represent, my Lords, the respondent number 2 in both the appeals.
So get the copy.
Please,
Whiling
Lords,
away the time in the name of getting copy, not availability of copy. Just whiling away the time. Get the copy. It is your duty to get the copy.
They'll have to serve me. My Lords, I'll take it from.
No
I had
time,
made that
sir.
request.
I've already
They are
served.
not yet served.
Notice returnable on.
Lord, I'll serve my learned friend again, Lord, with the hard copy as well. But can I seek one indulgence, Lord? But insofar as, Lord, the other respondents who are concerned, Lord, learned counsel, Mrs. Anupama Hegde has already appeared, Lord, before learned single judge. Lord, she is entered appearance, Lord, in 2 matters. In
I am
respect of-
appearing for Union of India in this matter, my lord.
So you're accepting notice? Learned advocate so and so appears online. Accepts notice on behalf of this member.
Lord,
The rest shall be served.
Lord, the other respondents, Lord, except Lord, respondent number 4, which is ONGC. The rest of them are all not the Union of India itself. That is not, she has entered appearance of 1, 3, 5, and 6.
You serve them, all of them.
Only respondent number 2 is my learned friend. And can I request not any date not in December, not subject to Lord's convenience? My
No time. We go to 17th January.
I seek some indulgence, not only this, not. We had 100 odd employees, not, who have been given not stepmotherly treatment, not by not the
Well,
company.
consider.
Very well. Not, my learned friend has also not served a copy of his appeal. If he,
His appeal.
his appeal. If
I'll
going to
serve
withdraw
them a
anyway,
copy.
then not have.
I'll serve them a copy.
It is on board.
Not, he has filed a memo for withdrawal not of his writ appeal.
So in all notice respective.
But-
Also.
but His memo for withdrawal of the writ appeal is there. Lords had not taken his memo for withdrawing this memo.
You are withdrawing the appeal.
No, so I am not withdrawing that appeal.
Why
That's
did you
what,
file?
may I submit this? What happened was, we challenged the, if I may just request to look at the direction issued by the learned single judge. Learned single judge holds that I can create a separate cadre as far as the writ appeal, the appellants are concerned. And the same benefits that they were drawing in the earlier OMPL can be extended to them. Because our contention before the learned single judge was, the pay scale that was given to them when they were in OMPL were contrary to the guidelines issued by the Union of India. In fact, Union of India has written letters to the erstwhile management saying you cannot enhance the salary and what has been done is illegal. In spite of it, the salaries of the employees were enhanced. And now the learned single judge holds that we should continue the same benefits that they were drawing by creating a separate cadre. That order, we challenged it before this honorable court in the present appeal. So thereafter, what happened was, the management thought that we can create a separate cadre and continue the benefit. So that is when once we issued the circular. That is now subject matter of another challenge before the learned single judge. And subsequently,
Please.
Number 13. State appeal.
Payment.
No, this is
Lordships
the.
have heard this matter substantially.
A
Then
direct,
synopsis is what lordships have directed us to file.
we have filed, the appellant has also filed its,
You have filed?
no,
Your file.
they have now filed a few documents along with the synopsis for the
No,
first time.
I'll just clarify. But my learned friend, not in his enthusiasm, has filed fresh documents, but I would request lordships not even to rely upon that. The gist of the synopsis may be taken into consideration so that the question is not whether it is a disputed question of fact. Order of the learned single judge makes it very clear that before issuing every bill, it was endorsed by the state authorities. And what's Central State Commission. And what's contract work, sorry, I'm sorry.
You are for original petition.
Yes, ma'am. Please.
Reserve.
May I just make one
Lord
clarification?
Learned Advocate, Mr. So-and-so, senior advocate, so-and-so, you are additional advocate. General?
Additional.
Learned additional advocate general, so-and-so, for the appellant. Learned senior advocate, Mr. So-and-so, so-and-so, assisted by learned respondent, original petitioner, at length. Learned was the party stated that the pleadings are over, that they argued the appeal finally. They further stated that the pleadings are over and no further are required to be added or supplemented. And reserved for judgment.
There is a contempt they have filed that will depend upon lordship's final.
Contempt shall follow the, in the contempt separate order. The present contempt proceeding shall yield to the judgment which may be pronounced.
Grateful.
So you may dispose of the contempt.
Yes, no, it can be disposed of.
Shall yield.
Could be disposed of.
Abide by the decision which may be pronounced in the writ appeal.
Please. Liberty to seek revival if so need arises.
With this observation, the contempt petition is disposed of at this stage.
Please. Grateful.
Number 14.
I appear for the appellant, my lord. This
14.
appeal is by the corporation, my lord, KPTCL, my lord. There is a delay of 12 days, my lord. Kindly it may be condoned.
Notice,
No, my lord. A stay is required because execution petition is already filed.
no stay can be granted unless delay is condoned. So notice written.
Only 12 days, my lord, and execution petition is listed on 24th. Lord, there are
24 of
24th of November, my lord. Second time it is coming up. Kindly,
take time on the ground of issuance of notice. 16th of December.
much.
Cell number 15, Sir Jay Prakash Reddy.
Same notice. 36 days delay. 17th January.
17 January. 16, 17 are urgent. Cell number 18, Mr. Nasim Raju.
16th का क्या होगा?
Yeah, for the. Additional matter.
18.
This is a matter. Lords, in this matter, Lords, the petitioner, Lords, had filed a KVA.
Dispose of the claim.
Lords, it appears the copy has been served, Lords, on the counsel who represented, Lords, the petitioner, Lords, in the petition.
Notice written in 20th January.
Lords, may seek, Lords, any day, Lords,
No,
in the
no,
next month, Lords.
no, not possible.
Lords, happened, Lords, in this case, that the parties, Lords, are deputed. Lords, the learned single judge, Lords, considers that it is a transfer order. That is how, Lords, the order is passed.
Next.
The impugned order, Lords, is not set aside.
On that they will consider.
The commercial appeal.
19th notice written on 22nd January. Delay of 15 days.
Notice, 22nd.
20,
Number 20,
also same order, notice written on 671 delay. late delay.
I am appearing for respondent.
So,
Petitioner.
Will issue notice,
My
23rd
lords,
January,
in this
23rd
matter,
January.
671 days, it's a commercial appeal, my lords. There is a 671 days delay in this matter, my lords.
We'll
So they
see.
are not ready to appear, my lords.
On that day, we'll see next. 21st already adjourned.
21 urgent. Cell number 22, Venkata Varnakara Reddy.
I beg to present Mr. Gaurav Milord. This is a
Go-
commercial appeal filed against judgment and decree of the commercial
Sir, for
court
respondent.
Mysuru.
For respondent,
I am appealing for the appellate. Milord.
appellant.
Lord, this is an appeal filed, Lord, against the judgment and decree of the Mysuru Commercial Court, Lord, wherein my.
Will issue
this-
notice written. 20th January, next.
Lord, they have already filed an execution application before.
Then deposit the amount. Money decree.
Lord, it's a suit based on an account, Lord, may I just,
Whatever it is. There is no exception in depositing the amount. If you want to stay.
Lord, Lord, I will take a chance after taking the notice, if the notice is served, Lord, I may be permitted to take out personal
Yes,
notice. Lord, some date may be fixed, Lord, some
Date
date.
is already given. Which date is given?
20th January.
20th.
What is the date, sir?
Cell number 23, Mr. Amit P. Mandagi. 23,
The appellant in this matter, Your Honor. Senior counsel is coming, Your Honor. I think it's.
No, not possible to keep back. Take your date. Next.
cell number 24,
Your Honor, Your Lordship, in serial number 23, at least the interim order may be extended here.
It will be extended.
Yeah, it's a response.
20th January, interim orders will be extended. If it is granted, other.
cell number 24, Mr. Sridhar BK.
Please, my lords. I appear for the appellants.
Appearing for respondents.
The commercial appeal, my lords, in this, the Mysore District Judge Court has given the judgment and decree.
What?
But this suit was filed for damages.
Any district judge may have given. Why you are saying Mysore district? We are not concerned with any particular district judge.
May,
Notice returnable. Don't make such submissions.
please, my lord.
This district judge and that district judge pass judgment. It is not right thing to do by counsel.
Grateful.
Don't mention the none of the judge. Why you are identifying the judge while arguing?
Please, my lord.
Maybe Mysore district judge or maybe Mandya district judge. What difference it makes? Don't make such submissions before this court at least. If you are practice here, stop that practice of mentioning a name of the judge.
Yes,
23rd January.
because we had even challenged the jurisdiction, that's why I'm sorry.
Yes, next.
Number 25.
Appear for respondent in this case, my lords.
Yes,
Copies are not being served.
serve copy, 28th January.
Much obliged.
They're on, I have served the copy, my lord. They're on KV already.
Again you saw, second time. Yes, next.
Number 26.
My lord, I appeal for the
Arbitration matter.
appellant, my lord. I seek for a week's accommodation in this matter.
Week will not be possible. It will go up. 13th January.
Great. Interim order may kindly be.
As
extended.
requested by learned advocate, interim order shall continue.
Great.
Yes.
There. Complaints in contempt matters. But 27.
Appearing for the
Mohammed Shamil.
Appearing for petitioner, my lord.
Yes.
For respondent number 1, my lord.
So what is to be complied with? Sure. Select the candidate for the post of professor in Department of Obstetrics, Gynecology, in relation to vacancy notified. So
Just filing a memo.
what you have done?
Lord says contempt in this matter. Contempt of court matter.
Pardon?
It's a contempt of court matter.
My lords, you're filing a memo reporting the stay of this proceedings in SLP number 22128 of 20.
Like. Division bench judge. Serial number 23. Appeal was filed, appeal was filed. Against this order of learned single judge, appeal was filed.
Yes, appeal was filed.
Where is that writ appeal?
No, an order challenging this writ appeal has been challenged in SLP. ma'am.
How can it?
Yeah. Yeah. Against the writ appeal, then SLP has been filed.
Against this order of learned single judge, SLB was filed.
There's a WA, my lord. If you look into the memo, it arises out of a writ appeal 15.
Of 23, my lord, that has been dismissed.
Writ appeal, so this may not.
The writ appeal has been dismissed, my lord.
So what
The
contempt?
contempt is arising out of that order, my lord.
No contempt served.
Oh.
Order which is brought under the order of learned single judge dated 26 July 23, which is brought under contempt jurisdiction by filing this petition was appealed against, which was writ appeal number 1524 of 2023, which came to be dismissed on 10/6/24. Full stop. Today, when the contempt petition came up for consideration in respect of the directions in order dated 26 July 2023, learned advocate respondent Miss so and so for
Respondent number 1,
one and
initials, my lord.
Just one.
This respondent number 1.
produce copy of the order of the Supreme Court dated 27/9/24. They still leave appeal number 2128 of 24, which was against the judgment and order dated 10/6/24 in the writ appeal. Full stop. Paragraph. As for the said order, the apex court has stayed the print in order dated 10/6/24, passed in the writ appeal by the High Court. Paragraph, in the aforesaid view, at present, nothing survives in the country. They are disposed of. Full stop. The parties shall abide by the orders which may be passed by the Supreme Court, Honorable Supreme.
Obliged.
Grateful, ma'am.
Number 28. SB Mukanappa.
I filed an affidavit. I filed an affidavit on 26th September, my lord, complying the directions of this court, saying that the monies have already been transferred to the complainant's account. My lord.
Salary amount.
Yes, my lord, the salary cover.
Yes.
No instructions in my client, my lord. He's paid only. No instructions, my seniors.
No instruction, then we give you instruction that he is saying. Will show us the payment.
He's paid only amount
The last third paragraph.
So you're aware that the amount is paid.
No.
If you are making a statement, we'll dispose of. Yes, learned date of it. Yes.
No, man. Only have it in tomorrow, my lord.
No, where is the?
My lord, the affidavit is filed on 26 September 24, my lord.
And
The
for
third
what
paragraph.
you are appearing?
He's paid only contract basic amount only, madam. Contract basic amount only paid.
So what is this?
Lord,
Salary?
Not fully complied this. That's what.
Yes, you
If
may.
you give us, my lord, what is not complied.
First the.
My lord, it's on the affidavit, my lord, third paragraph on
Where is
26 September 2024.
26 September, yes.
Third paragraph.
Paragraph 3. Sum of rupees 11,60771 and so and so transferred by of salary to the complainants and also to so and so. The directions of learn a single judge.
My lord,
In order dated
kindly pass out the matter, madam.
23. No, 23rd of November. Why pass over?
A senior will come, madam.
In this, no senior is necessary.
But, no instruction to my seniors. Senior is held up on another court hall, my lord.
So that is not our lookout. It should come before the first court first. 2:30.
Much so.
Now mentioning that the counsel is before other court. This is first court. You must request it first, respect it first. We will not henceforth entertain such request. Yes.
So number 29. Okay, Prasanna Shetty.
29, I am referring to the complaint.
Serial number 29.
Complaints affidavit, my lord.
Complaints affidavit has been filed, my lord.
Please declaring is, it is filed, my lord.
Complied with?
Complied with, but not, my lord. The consequential benefits are not at issue, but
What are
they have
the
taken an
Order has
undertaking
been
that
passed, my lord.
What are the directions?
for direction to pay all consequential benefits, my lord, and declare his probationary period. Lord,
Not paid.
but, my lord,
Not paid.
probationary is declared, my lord, now.
But
File is with the
benefits are not.
benefits are not yet paid, my lord.
Order has been passed, my lord, that will follow. my lord.
Where is it order?
Page number 6, my lord, is the order.
Page number 6.
Page 6, annexure R1, my lord. The order has been passed, my lord.
Next R1, yes.
After calculation, it will be.
So you take instructions when you will pay the amount.
Please, my lord, 2 weeks' time may be granted, my lord. We will,
In seeking instruction as to the time when you are paying amount.
next week, my lord, sometime next week.
Monday at 2:30.
Please.
Send over to 25th at 2:30, on which date learned additional government advocate, Mr. Harish, shall take instructions as to within what time the
Please.
consequential, as to within what time the benefits to be paid consequential to the Order dated 31/7/24, passed by the Joint Secretary, Service 2, Department of School and Education and Literacy, Primary, into bracket, Annexure R1, page 6, to the compliance affidavit, bracket or shall be paid.
Please.
The petition.
Deeply obliged.
Number 30. Ajay Kumar Patil. Ajay Kumar Patil. Party in person.
Not there. And keep it on 19th of December.
Number 31. Shabila Shichas.
They have complied with the direction passed by the Honorable Single Judge. The content may be disposed of.
Learned advocate, Mr. So and so, clearly stated that the directions of learned single judge are complied with. Full stop. Learned additional advocate, additional government advocate confirms the compliance. In that view, things arise in the contempt, present contempt petition, it is accordingly disposed of.
Grateful.
Number 32. Okay. Swami NBN. Number 32. The Swami NBN.
Not there. 18th of December.
The compliance affidavit is filed, my lord, let them respond.
18th of December.
Number 33.
Yes.
Compliance affidavit as filed.
Complied with.
Right.
You are co-respondent.
Sir?
You are co-respondent.
Yes, ma'am. Please.
What is it?
33.
How serial number?
33.
Swami NBN.
17th December.
17.
No, it's not there. Where is the compliance?
Filed on 19/11/2024.
Pardon? Page?
Separate affidavit. Separate affidavit has been filed.
What is?
Affidavit is filed.
Where is that? That is what we are asking. Where is that affidavit?
Yes, number also.
Page?
Contempt, 778. No,
18th
is the
December.
number. 668, government has filed the compliance.
18th December. Next.
18 December. 18 December. Number 34. Mr. Sampath A. 34. Sampath A.
17th December.
Number 35. Mr. Srikanth MB.
I appear for the
35.
Not fully complied, my lords. As per the award notice, my lord, they have issued only 33 lakhs, my lord. As per the award notice, my lord, 70 lakhs has to be paid, my lord. I will file the rejoinder, my lord, to the compliance affidavit, my lord. 1 week time may be granted, my lords.
23rd January, as requested by learned advocate to the petition. Next.
Number 36. Mr. Ramesh KR.
My lord, I appeal for the complainant in this matter, my lord. They have filed a compliance affidavit. The direction issued by the learned.
Not filed.
Please, my lord.
They have not filed.
They have filed.
Compliance has been
But
filed.
they have not complied the order passed by the learned single judge of this honorable court. Your lordship may kindly peruse the affidavit filed by the compliance affidavit filed by the accused. Lord, para 4, my lord. In view of the said settled position of law, an endorsement dated 28/8/2004 has been issued to the complainant, rejecting the application for Podi and Durust of the land bearing number so and so, so and so. Now your lordship may kindly peruse the endorsement, my lord, at annexure R2. I'm sorry, my lord. Annexure R2. Translated copy is at.
Now this Tehsildar doesn't know.
There's a mistake, my lord, in the session. I will get it rectified.
Learned advocate, learned additional government advocate admits that the endorsement dated 8/8/24, which is produced along with the compliance affidavit, to submit that it marks the compliance of the jurisdictions of learned single judge, is in fact does not amount to compliance of the court's order, full stop. Tahsildar, Yalanka, Taluka, Yalanka is prima facie guilty of evidence of court's order, full stop. It amounts to contumacious conduct which may partake the contempt of the court unless the remedial action is taken before the next date. Full stop. Stand over to 13th December to be listed at 2:30 on that day, unless the remedial action is taken and the order is shown to be complied with, stern view will be taken.
But similar endorsement is issued in serial number 10, list number 2, minutes. Very similar in another matter.
Yes, next.
Please.
December 37.
Serial number 37, my lord. Yeah, for the accused.
The complainant's counsel, my lord, seeks a week's time.
May I just make
Complainant's
this?
counsel seeks a week's time.
Well,
Why?
normally I would.
Comply with some office.
My lord, my lord.
Office objections.
May I just make this one submission. Normally, I would never oppose any request, but kindly see how this, it's all something that is being played out. Contempt is connected with an OSA, which is a company side appeal of 2016. The contempt complained of is alleged violation of an interim order of sometime in 2020 and 21. The very appeal, the underlying appeal, came to be dismissed for non-prosecution. They repeatedly never appeared before this honorable court. In the meantime, during the pendency of the undertaking was not to alienate a certain property. After the appeal got dismissed for non-prosecution, they filed an application to restore. The division bench dismissed their application, saying there was no reason forthcoming. That is when, my lords, when the appeal was no longer surviving, we went ahead and sold the property. Now, my lords, 1 month later, they get the appeal restored, and now they have the contempt connected with the OSA. Well, my only difficulty is this. There was a scheme of arrangement which was arrived at way back in 2015, approved by this honorable court. They file a review petition comes to be dismissed, and who is they? They are the employees. In fact, the matter was sent back in 2006 for the employees to be heard. The learned single judge, upon remand, notes that the employees have not come out with any scheme at all, and then approves. So, and then, in fact, the company was ordered to be wound up. Now, it's just stalling we want to implement the scheme. We want to revive the company. These are the. I'm sorry, Manoj.
16 is the order.
Page 16. No, sorry. Page. If first order, Manoj, page 14. Your lordship has the contempt.
Contempt.
Page 14. Kindly see the second paragraph, Manoj. Shri so and so. Senior counsel appearing on behalf of the 6th respondents on instruction so-and-so submits that on account of there being only a lease cum sale deed in favor of the 6th respondent, for the present, 6th respondent is not contemplating of selling the property. That was the order dated 23/12/20. Now, my lords, may kindly see page 16, which your lordships were seeing a little earlier.
So contempt is alleged in respect of this.
Against these two orders. Now, the sequence, if my lords were to take the OSA, the order sheet will reveal that on 5th of September 2023, the OSA was dismissed for non-prosecution. That order sheet, if your lordship wants, for the sake of convenience, we made a convenience compilation. My lords may kindly see. Just give the 5th of September order distribution.
Yes, Mr.
Maharaj, may kindly see page 89 of this compilation. 5th of September 2023, page number 89. Kindly see at the bottom, my lords. After noting so-and-so's absence, OSA is dismissed for non-prosecution. This is order dated. My lords, may kindly see the dates are relevant. 5/9/2023. My lords, may then kindly turn to page 94. Kindly see the third paragraph, my lords. This application IA number 2 of 23 is filed by the applicants seeking to recall the order dated 5/9/23. And without troubling my lords reading the entirety of the order, kindly see at page 97, the 96 running on to page 97. the IAA stands rejected. So 5/9/23 followed by 23/9/23. Now the alleged contempt is a sale deed dated 13/12/2023. The appeal 23, and the appeal got restored in January 24. So on the date on which the sale deed was,
It is restored when?
I'll just point out, restored on 9/1/24.
Where is it order?
That order also, my lords, will find in the same compilation.
Page 97 is rejection of.
Yes, sir, it's a rejection. Then
Again-
once they filed one more, page 101. Sorry, I'm so sorry. Page 105.
This IA 2/23 was what?
Reject. That was for recalling the order for which
Again, they filed.
they filed one more application that was considered at page 105. And then the appeal was once again restored. It was in this interregnum, my lords, that the sale deed was executed. Now, I ask myself, when there is no appeal pending, there is no interim order that goes without saying. So therefore, where is the contempt?
No. 105.
105, and at 107, 106, it stands restored again. So that OSA is now connected along with the contempt.
Contempt is which of which order, right?
Contempt alleged contempt is of the orders dated 23/12/20 and 3/12/21, which my lords found at pages 14 and 16 of the contempt application.
14 and 16 of contempt.
Yes, my lords.
14. So that is of page 2020.
Correct, my lords. 23/12/20 and 3/12/21. Sale deed dated.
Even order is at page 16.
Yes, my lords. 21 was at page 16. Then just to complete the sequence of events, dismissed for non-prosecution on 5/9/23. IA reject again on 23/9/23. Sale deed executed 13/12/23.
Nothing to this. You have to say nothing.
My lord, I'm the petitioner. My lord, I have prayed for a time of 1 week.
No. Why? It's so clear are the facts. And it is interim order.
My lord, I pray your lordships to pass no order because I pray your lordships to pass no order because my senior
For
counsel.
passing orders, how can you say that you pass no orders? We are here to pass only orders.
Until I'm represented, my lord. The senior counsel has left the shore, so he'll come back day after tomorrow, my lord. At the beginning itself, we have prayed for a time of 1 week, my lord.
No, why?
The senior counsel is on his legs.
I know why you are not seeking 2 weeks time.
My lord, we have to file
Why only 1 week?
rejoinder application, my lord. We are yet to file a rejoinder application, my lord,
Nothing.
to this
So
account of
this,
David.
the present heard learned counsel for so and so for the petitioner and learned senior advocate Mr.
Vikram.
For the respondent assisted by so and so. Contempt jurisdiction of this court under the Contempt of Court Act 1971 is invoked by the petitioner in respect of the order dated 23/12/2020 and 3/12/2021. Full stop. Order dated 23/12/2020 paragraph reads as under quote the entire paragraph. The other order, which is also brought under the contempt jurisdiction dated 3/12/21, is extracted here under page 16 or page 15 or 14 or 15, page 16. Full stop. In course of the submissions from a learned senior advocate for the respondent could undisputedly point out that the original second appeal.
Yes, original side appeal, OS.
No?
Original side appeal.
Yes. Original side appeal was once dismissed for want of prosecution as per order dated page
5/9/23 at page number. Let's just show me that memo. Sorry.
Yes.
At page number 89, I'm so sorry.
5/9/23,
Page 89.
which order figures on record. Thereafter, application number, interim application number 1 of 20, application number 2 of 2023 was filed seeking restoration, which application came to be dismissed on 23/9/23. Which order also, copy of which order also is on record. Also, it appears that the appellant had filed yet another application seeking restoration of the original side appeal, which was IA number 3 of 23, which came to be allowed on 9/1/24.
9/1/24, that's it.
So it was submitted on the basis of the above sequence of dates that during the time when the the orders under contempt relate to the time the original said appeal itself was dismissed for on to proceed. Full stop. Be as that it may. Paragraph. The weighty aspect for the court not to entertain the contempt petition is that the said orders are not only challenged after 2 years, they are interim orders. Original said appeal is pending. When the orders are interim, by their very nature, they do not determine the final rights of the parties finally, since the main proceedings are pending at large to be decided on merits. The court is not inclined to exercise the contempt jurisdiction. Parties are at liberty to work out their rights and remedies before the
Could I request
in the original.
Grateful, ones. Now, could the appeal also be posted before either your lordships or the roster?
Which appeal?
The main appeal is also listed, connected along with, because the complainants had the main appeal connected along with the contempt. OSC.
This which appeal? Company petition.
Yes, ma'am, it's a company side appeal.
And OSA number, company petition number 34 of 2014 and OSA number 8 of 16 shall now be posted before
the roster
for taking up such matters.
Grateful.
As for the prevalent roster.
So great.
Number 38, the Keshav R. Agnihotra.
No, the non-compliance with the order,
You have complied and filed the affidavit also, Millards.
non-compliance with the order, Annexure A, writ petition 15974 of 24. So order dated 4th July 24, not yet complied. So that's why I've come up in contempt.
Millards, we have filed affidavit, Millards, that we have complied.
Or
On
July
15
not complied, what is the direction?
To consider their representations, Millards, we have considered and passed the necessary orders.
In the writ petition, there was an order to consider the representation and to do as per law. So later on, the representation was made. Now even after representation, there was no communication. So there was no communication with regard to the representation and compliance of the this honorable court. So I have come in contempt. And I have lodged the complaint contempt before this court.
Now it is complied.
And
copy, madam.
We have served
You're
the
not
copy,
giving
Millards.
copy, then how
We have
they will-
served the copy, Millards.
no, not received.
Second time show that.
I'll give one more copy, Millards.
You have not produced the endorsement. Not produced the endorsement, even in our chat. While
Let's,
the case of the compliant respondent is that while the case of the respondent is that the affidavit, that the endorsement is received and the same is filed along with the affidavit of compliance from us. The record does not witness any such endorsed copy of the endorsement produced on the record. Produced, full stop. Therefore, learned advocate Miss so and so shall put her house in order, full stop. The contempt petition shall be listed at 2:30 on 26th of December.
please,
November.
November.
Put
It is
the-
here, Millards, I'll file it
Put the
right.
copy here
Please,
and give copy to him.
please, Your Lordship.
He is very eagerly waiting for.
Number 39.
Appear
You
for
want
the
to
Nine,
copy or
my
not?
lord, the compliance affidavit
I'll
is filed, my lord.
Appear for the complaint, my lord.
Compliance
The-
affidavit is filed.
The order has been complied, my lord.
Learned counsel Miss so and so stated that the order of contempt used contempt brought under this petition is complied with. Learned additional government advocate the compliance paragraph. In the above view, nothing survives in the present proceedings. The petition is disposed of as not survived. What is the name? This is 39.
39 minutes.
Number 40, to Siddharth Kumar.
For responding. Matter.
What is it? Read petition.
Lord, I pray for some short accommodation. I pray for short accommodation.
24th January, as requested by learned advocate for the petition. It is 2018 matter. What is it about?
2018.
18 and 9.
So it is 2028 matter. It is 2018.
Next date we will go on, my lord. Next
Finally,
date we will
already
go
we
on.
have filed compromise petition, my lords, in the 36679.
No, there is an IA, then on the last occasion, my lords are the opinion that court will not get into the compromise. We will have to go on with matter, my lord. We will argue it.
No, like that it is, they have told, we were directed to file affidavit. We had filed an affidavit on 29 June itself, my lords. But the company had not come up with any affidavit in 27261 of 19.
What will the review petition? I don't understand. 760 days. Delay.
It's, there is nothing. It's already the court reported order.
Where is that order? Nothing is there.
So when do you want? 26th will take up.
Please, my lord.
26th of this month.
Please, my lord.
You file a reply.
I have filed my affidavit.
Page.
Was separated in
When it is filed. Doesn't figure on record.
Please, my lord.
Not available. When it was filed.
Was filed in review petition 217 on 29 June 2024, my lords.
217.
Yeah.
So review of this very order.
No, review has been filed by government.
My lord, I am one of the
I'm
investors.
informed that
Just matter because we can recollect.
We have heard this one.
my lord, I am dealing it for the first time, my lord. This is a case where, my lord, the violations of auction had been violated. The EMD of 25% had been deposited.
Hold it. Third December.
In my petition, I have something to say. 26, I may be permitted to. My lord, here, my lord, in the nutshell, I will just give you the list. A person who is a company representative for the auction of the iron ore, he has collected money from the investors and the amount was supposed to be forfeited. Then he approached this honorable court in the company name. This honorable court directed the money to be paid to the company. Thereafter, with regard to the interest, he paid a petition saying, let it be come in my name. If the money goes to the individual, the investors will be at risk. So they approached this honorable court. This honorable court directed, let the money not be dispersed to the private individual and the money deposited before this honorable court. That is the gist, my lord. And here I am for the private investor, hard-earned money by beg, borrow, have paid to the money. Now, our only interest to get back our money, my lord. We are not against anybody.
That is a prayer, what we made. And with regard to the locus, my lord, in the petition, we have narrated about 5 judgments, the relevant paragraphs also, saying that even if it were to be a stranger, he can maintain under 226. We have brought out, my lord.
Sir, kind permission, because this matter like what my friend is submitting. Already we have filed a compromise petition in 36679 of 18.
My lord, if compromise is accepted, we have no problem.
Compromise
Compromise,
petition
we
is there
have,
and we have been
even
directed
today
to
we
file
stand
an
by.
affidavit.
We stand by that compromise. But last occasion, my lords were of the opinion, it is interstate dispute, so we will go by legality.
We were directed to file an affidavit. We had filed an affidavit in review petition, but the company said they had not filed. And there was a dispute between the advocates, like they are not given an NOC. Now some new advocate has come up in the matter. Because we heard and we passed orders.
My lord, the investors, the petitioners' interest may kindly be safeguarded. My lord. We have nothing. We are in actually, at one stage, the Honorable Court protected. Subsequently, he filed and inadvertently order came to be passed. That order we are seeking.
Next.
Much
41.
Please.
This is the matter, my lords, pertaining to the high security number plates, which your lordships had indicated is to be heard finally. I would like to prepare a convenience compilation for your lordships, my lords, before the matter is taken up, because there are multiple appeals and pleadings filed in each. So my respectful request before your lordships is to kindly have the matter at 2:30 on any day convenient, my lords, in the next week or so. And I will place, my lords, the convenience compilation before your lordships.
Can I make one suggestion, man? It's against an interim order.
Number plate.
No, number plate. It's against an interim order, man. It's against an interim order. All that can be done before the single judge and argue the main matter itself, man.
It is against the interim order.
It's against an interim order. Appeal is against an interim order.
The state is also before your lordships in an appeal.
Let the interim order.
Sir, I'm Gauri Shankar, party in person. I'm joining on video conference. I want to make a submission, my lord.
Let the interim order continue, my lords, and let the whatever is there as on today for both the parties, and let the matter be.
Yes, my lord, I appear.
I think that would paper book will be saved.
Yes, Mr.
But as I pointed out, my lord, we have, it is in our notification. We have identified 3 methods by which the.
That's on merits, my lord.
But time to time, the orders are passed in.
No, the solution for this is if the state government decides on a process. In fact, if your lordship look at item B in the final directions issued by the learned single judge.
Yes.
Please have a look at item B in the learned single judge's direction.
Page 55.
Learned single judge said, state government within a period of 15 days from today shall finalize and publish the process that is to be followed by vehicle manufacturers to accord approval for every license plate manufactured with type approval certificate.
That has been stayed, no? This has been challenged and stayed. Let the interim order continue, my lords. We'll
I think all issues.
we are in appeal challenging it. Why should we comply?
Yeah.
You're agreed by that portion.
From center, we pointed out 3 methods.
We adopted one. Any one of them could be adopted.
No, that's not the stand of the center.
That
We
is
have
the.
not given a choice.
We adopted the 4th one.
Who is for the petition?
Lords, I appear for the appellant. Now that my friend has made this suggestion, Lords, I'll come back to your lordships in 2 or 3 days after consulting my instructing counsel. It seems the proposal is that, my lords, the matter be placed before the learned single judge to decide the main matter, while keeping, my lords, the interim orders in force till such time an expeditious decision is made. May I come back to your lordships in 2 days after consulting my instructing counsel on that, my lords?
Then 25th or third, whenever you want.
Third, your lordships may have it, my lords.
Third at 2.
Please.
Sir, this is Gauri Shankar, sir. I want to make a submission, my lord.
1 minute, Mr. Gauri Shankar, but the interim orders may kindly be continued.
Stand over to third as requested jointly by learned counsel for the parties. Interim order operating in the appeal shall continue to operate till.
Grateful. I'm grateful.
Instead of the third, can I request for the fourth, subject to your lordship's pleasure, my lord?
Fourth, no
Final.
difference. Fourth.
Grateful, my lord.
Fourth December. Interim order shall continue till fifth.
Please.
Grateful.
Sir, can I make a submission, my lord?
Non-filing of reply in contempt matters.
I seek for 2 weeks
Cannot
accommodation,
yes,
my lord.
Joey.
Serial number 42.
So 42 will go to, nobody is there,
Sir Ranganath Joyce.
20th January.
Number 43. Adinarana.
Appear for the accusation. My lords, my instructions are order has been complied with, but there's one issue, my lords, the accused has retired since March. If you can carry out the amendment, I'll be able to file the compliance affidavit with the new incumbent.
It is complied with, then very busy.
My lords,
If it is complied with, then what is the relevance of retirement?
if I have to file the compliance affidavit, I need a signature.
File it. When you will?
It can, whenever they can amend.
Last 1 year, they have taken the time.
Now they are saying that complaint, give copy to. When you will file complaints? Fourth?
My lords, if they change the name to the new incumbent, I can get the signature.
By fourth?
My lords?
By 4th of December, we'll file.
Yes, my lords.
Learned advocate, so and so for the respondent.
AWA is in Bangalore.
Submitted that compliance will be filed within.
Out of the fight side.
Will be filed before the next stage, stand over to fourth.
Permitted to amend the name of the accused number 3 in the cast title. Permitted to amend the name of the accused number 3 in the cast title. I will make the.
Copy has to be served, my lord.
Has to be served.
I'll do that, my lord.
For-
Non-compliance in listed.
For December. Learned additionally, government advocate states that the order is complied with. However, the copy of the compliance affidavit is yet to be served on the counsel for the petitioner. In that view, put up at 2:30 on 4th of December. Copy shall be served to the respondent within 4 days. Within 4 days you serve.
Please. Number 45. Usman Tahir.
Direction is to comply within 4 weeks, my lord. The date of single judge order is on 15th December 2023. Till now, my lord, they have not complied. Lordships will get that direction at page 31. My lord, the directions, my lord, at page 31. Lord, this order is passed on 15th December 2023, my lord. Compliance should be done within 4 weeks is the direction issued by the.
Who appeared?
Lord, sir, is already.
Who appeared for BBM?
My lord, Mr. BL Sanjeev has already made his appearance, my lord, in the cost list. Sanjeev BL.
Somebody has already appeared in the matter.
It is there in the cause list, my lord, his name is shown.
Name is shown.
Mr. BL Sanjeev's name is already shown.
No.
45 and 46 is the same matter.
Oh, Sanjeev B. LSAB.
Yes,
Give copy to of this petition also.
we have already done it and they
Then
have
we-
made up.
Keep back.
Also,
Inform. If he is appearing, then we'll wait. Yes.
Please.
45, 46, also. 47. Srinivas K.
Lord, I appeal for the complainant in this case.
Complied, it's complied with, I just need to serve him. Any day next week at 2:30, I'll just place it on record. 47 and 48, both here.
Let them complain, and I have no.
Like, it's already
47
complied,
and
I just
48
need to
both.
file it.
Both. Learned advocate Mr. Chandra Choud.
Fact, this is more regarding the sanction of increment, which has been.
Order is complied with and that he will file compliance affidavit after giving copy thereof to learned advocate for the petitioner, Mr. So and so. So such exercise will be completed within 1 week. Put up on 4th December at 2:30.
At 2:30, it may be taken. Deep blue. Both here, 47 and 40.
About 49. Mr. Sampath. 49. Mr. Sampath.
My lord, appearing for petitioners, a short accommodation, my lord, senior is not aware.
The request of learned advocate Miss so and so for the petition extend over to 23rd January.
Please. Order's been compliant, I'll serve the others. Order has been compliant.
You understand?
I'll serve them all. By the next date, I'll serve the.
He doesn't have the instruction, doesn't have the papers.
Yes.
That's him.
Where are your papers?
My lord, it's with senior, he's.
All right, we are giving time.
This is number 50. Samit, yes.
The complainant, my lords. Order dated 25th of April 2024 to carry out Podi and Durust work in the.
Take 2 weeks accommodation, my lord, while the compliance affidavit.
21st is January.
Non-full.
As requested by learned advocate, learned additional government.
Yes. 51. So Madhusudan J.
The accused, my lords, the authorities have preferred an appeal against the order brought under contempt. May I pass on the number of the writ appeal, my lords? It's a filing registration number, my lords, 1721 of 24.
Stated that the appeal is filed against the order brought under.
May I make a submission, my lords?
In this order brought under the contempt of court. First of in that view, this petition will be listed on 21st January.
May I make a submission, my lords? This present writ appeal, they have filed after passing of 2 years, my lords. Only in order to avoid the contempt, they have filed the writ appeal.
Before which time the complainant shall be obtaining appeal orders in the appeal, failing which the respondent shall be liable to comply with the direction, right? You are giving time up to 21st January to obtain the orders.
Please.
Appeal.
Please.
If not obtained, then comply with the
Please, my lords.
Number 52. To Ramesh KR.
Complaint in this matter, my lord, we may be put in liberty to challenge the endorsement issued by them.
This matter I appear for the accused, my lords. I may be permitted to file my power. In the next course of this week, I'll file my wakalat. In the course of 4 weeks, my lords, I'll do the necessary payment.
4 weeks.
Which serial number?
4 weeks.
56.
926, you contempt 926.
52.
My lords, apologies.
I'll pass on the compliance affidavit, my lord.
complied with.
Compliance affidavit has been filed, my lord. Endorsement has been issued, my lord, considering this.
Following were the directions of learned single judge in its order dated 5/4/23 while disposing of the brief petition. From extracting the operative for page 25 is bracketed. It is the aforesaid directions which are complained of about their non-compliance, for their non-compliance. Upon issuance paragraph, notice in the present proceedings, respondent filed compliance affidavit dated 5th November 24, in which it is stated thus in paragraph 5 of the affidavit. It starts from in pursuance of ... in pursuance of the receipt. Committee for Education. Thereafter stated in paragraph 6 that the application was placed before the committee on 25/10/2024. Copy of the decision taken by the committee was also produced. The endorsement dated 26/10/24 came to be passed, rejecting the application of petition. The endorsement is produced on record, integrate at annex, not integrate, at annex R2. In view of the above, there is a compliance of the direction, learned a single judge, nothing survives in the present contempt proceedings. It is disposed of. If the
I may be put in liberty to challenge that.
petitioner has, liberty is reserved for the petitioner. Independently challenge the endorsement on merits, if so advised before the court by initiating appropriate proceedings in respect of which this court does not express any opinion on merits.
Much.
Number 53 to Madhusudan J.
Lords, I've handed over the demand draft to my learned friend today.
I received the DD, my lords. We have asked like 4,82,200 rupees. They have given 4,02,000 DD.
I'm placing the copy of the DD on record, my lords.
Learned everybody, petitioner stated that the petitioner received rupees 4,02,386. 4,02,386. Full stop. This is confirmed by learned respondent, Mr. Sir, by producing memo dated 20th/11/24, which is taken on record. Paragraph. The memo refers to the payment, said payment and draft dated 19/11/24. Full stop. In the above view, in view of the above developments, the directions of learned single judge are complied with.
Lords, they are disputing
Nothing survives.
they are disputing the amount, my lords.
Nothing survives in the complied with. There is substantial compliance. Nothing survives in the contempt proceedings. It could not be said that any of the respondent have committed any willful contempt. Full stop. It was submitted at this stage by learned the petitioner that the calculation is not correct. Calculation of the amount is not correct. Full stop. In this regard, it is open for the petitioner to approach the competent authority and sort out the calculation dispute.
Please.
Number 54, Mr. Vasant Kumar.
Proceedings are closed, disposed of accordingly.
Grateful, my lords.
54, Vasant Kumar HT.
Order has been complied, my lord. I'm filing the memo along with allotment letter.
Who appears? Learned advocate Ms. So states that the order is complied with. She produces copy of the compliance affidavit. Paragraph. The directions in the order of learned single judge was about executing necessary document and allotment of the site. Allotment of site.
Allotted, my lord. Allotment letter also issued, my lord.
It is done, allotted.
Allotted. Allotment letter also issued along with the memo I filed.
Where is that? The same site number 2085 is allotted to the petitioner. Prima facie, therefore, the contempt proceeding would not survive. However, since learned advocate for the petitioner is not present, stand out to 25th at 2:30.
Number 55. So, V. Rangaram.
That's we have received the Wakala's lordship. We will we'll enter into appearance while filing.
Yes, madam.
They want time.
Next week, madam. Next week, madam, may I
Not
request
week, not
for
week.
lots.
18th December.
The next week, may I request next week or earlier date, maybe.
Not. This is earliest possible.
56. Harish HV.
Lord, I appear for the accused, my lords. Lord, I will comply with the order in a span of 4 weeks, my lords. This is arising out of an RFA, the suit of ejectment. There's a compromise decree that was entered into. Now we have made a part payment, my lords. There's some amount remaining. There was a compromise decree that was drawn up. Now we have, according to the decree, we have made a part payment. The rest of the amount we'll make it in the next 4 weeks, my lords.
Compromise decree clear, my lord. On or before, my lord, 5th January 2024, my lord. Till date, my lord, not pay 1 rupee, my lord. And page number 12, my lord. Condition, page number 12, page, condition 2, my lord. On or before 5th.
What amount to be paid?
My lord, this is the arrears of rent that they're claiming.
What is the amount to be paid?
My lords, it's about 35 lakhs, my lords.
37 lakh due, my lord.
I'll instruct my party. My only seeking 4 weeks time.
Learned advocate so 6 time. To submit that within 4 weeks, the compliance will be obtained.
Please.
Full stop. In that view, the time is granted. The petition, contempt petition may be posted on 22nd January.
Please.
Within which time the compliance will be obtained, failing which the respondents will be exposed to aggravated form of contempt.
Great.
27 button.
My lords, my apologies for mentioning repeatedly. With your lordship's permission, my apologies.
Number 57. Nagarajappa.
Taking 2 weeks time, 57 complaints affidavit has to be filed. 2 weeks accommodation.
For the complainant, Lord. I'm for the complainant serial number 57.
You have filed,
I'm for the complainant, Lord.
you have the complainant. What is the direction?
Plus, they have not filed any reply.
Who appeared?
Lord, I'm seeking 2 weeks accommodation.
2 weeks. 18th December.
My lords, I am sorry for mentioning repeatedly. Serial number 58. Because I have traveled from Delhi for this matter. I see 2-3 final hearing matters for 2:30.
We'll take up.
This matter may kindly be taken.
We'll take up.
Please. I'm grateful. I'm grateful.
We'll assemble at 3 o'clock. Yes.
He's coming from Delhi.
Serial number, Rebecca. 57. Let us wait.
Madam, 68.
55 ಯಾರಿದ್ದೀರಾ 55 ಫಿಲ್ ನಂಬರ್ 55
Accused ಗೆನಾ?
ಅಲ್ಲ ಅವರು ಅದರ್ ಸೈಡ್ ನೇಮ್ ಬರ್ ಕೊಡಲ್ಲ ಅವರು ಇವರು ಮೇಡಮ್ ಬರ್ದಿದ್ರು 55 ಯಾರಿದ್ದೀರಾ ಮೇಡಮ್
ಮೆಡಿಕಲ್ ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
55 accused ಗೆ 57 complainant.
ಟೈಮ್ ಅವ್ರ ನೇಮ್ ಬರ್ಕೊಡ್ಬೇಕು ಅದೇ ರೀತಿ ನೀವು
ಕೊಟ್ಟೆ
ಕೇಳಿದ್ರಾ?
ನಾನು ಬರ್ದು
ಅಲ್ಲ ನಿಮ್ ನೇಮ್ ಇಲ್ಲ ಅವ್ರದ್ದು ಕೇಳ್ತಾ ಇದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೈಡ್
ನಾನು accused ಗೆ
ಬರ್ಕೊಡಿ ನೇಮ್ ಬರ್ಕೊಡಿ ಇಲ್ಲಿ ಬರ್ಕೊಟ್ಟಿದ್ದೀರಾ ನಾನು ನಿಮ್ಗೆ ಇದು ಕೊಟ್ಟಿದ್ದಾನೆ
ಅದು
ನೀವು ಅವರ ಕೊಟ್ಟಿದ್ದೀರಿ ಸರ್ ಮಧ್ಯಾಹ್ನ ನಿನ್ನ ಹೆಸರು ಫಾರ್ ಅಕ್ಯೂಸ್ ಅಲ್ವಾ ತಪ್ಪ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಇದೆ ಸರ್
ಆಮೇಲೆ ಏನು ಅಂತ ಬಂದ್ಮೇಲೆ
55 accused. Endorsement
ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಆಗತ್ತಲ್ಲ
What officer, sir? So, serial number 71, sir.
Court officer.
ಹೇಳಿ ಸರ್ ಯಾರು ಮಾತಾಡ್ತಾ ಇರೋದು
Sir, serial number 71, sir.
71 ಏನ್ ಬೇಕು ಸರ್
Sir?
71 ಇನ್ನೂ ಕಾಲ್ ಮಾಡಿಲ್ಲ ಸರ್
Okay. ಮಧ್ಯಾಹ್ನ ರೆಸ್ಯೂಮ್ ಆಗ್ತಾರಲ್ಲ ಸರ್
3 o'clock ಬರ್ತಾರೆ ಸಾಹೇಬ್ರು ಹೇಳಿ
3 o'clock, sir.
Court officer? Court officer?
Serial number 90.
90.
90. The notice dispatched, but still it is awaiting.
Await. All right. So when do you want? January?
Yes, my lord, it returns, it is KSRTC is here only, in the December end.
Endorsement shows that notice to the respondents have not received back. In that view to be posted after the service of notice. On 10th January.
Much.
Yes, seal number 11.
And the accused land was acquired in 19, the preliminary notification was issued in the year 1963. 69, the final notification. The award was passed in the year 1972. But award notice, though the document was produced before the learned single judge, it says it was served on one of the family members, but his signature is not, it is not, we cannot say it. But award has not been, admittedly, award has not been deposited or paid. It has not been paid or deposited. Possession has also not been taken. We are in possession of the property. Therefore, my lord, my respectful submission is the delay, whatever it has taken place, it is inured to our benefit for this reason. Because of the delay, my lord, we are continuously in possession of the property. Therefore, section 24(2), my lord, is squarely applicable to this case. Is my respectful submission. Lordship may kindly see section 24(2). In indoor development case also, my lord, there are two conditions has to be fulfilled. One, the award has to be passed and either it has to be deposited. If not deposited and possession not taken, then it lapses. Suppose the amount is deposited, possession not taken also, they are not applicable. There are two concept, events has to take place. In this particular case, award not deposited, not paid, possession not taken. Therefore, section 24(2) is applicable. This is my respectful submission. This is the point. Lordship may kindly see this.
Like.
That is the view of the Honorable Supreme Court also, my lord, in one of the matters. Please see section 24(2).
All right. You are appearing?
Is appearing for the state.
1 and 4, man.
Number
1 and 4, I shall be appearing.
Lordship may kindly order notice for respondent number 2 and
Is
3.
respondent number 2, my lord.
2 and 3.
2 and 3.
Dismissed.
But there is one judgment, but may I request Lordship to see this judgment. Indoor development.
We'll give the reasons. Sir, next.
Number 28. So Mukkanappa SB.
A memo regarding my lord.
This is what?
The accused pay the 11,62,771 month instead of 13,87,628 month. That reason, my lord, I filed a memo regarding my lord. They have not fully completed the order.
That salary. Show that it is paid.
My lord, affidavit, my lord, 26 September 2024, my lord, I filed an affidavit. At para 3, my lord. I've made a submission, my lord. They accept that it is 11 lakhs which is being paid, my lord. They are asking another 2 lakhs which is excess.
2,24,857, my lord. We
Para
paid.
3, my lord.
What is this?
They filed a memo stating that there's a difference of 2 lakhs rupees which has to be paid. Not sure how it is calculated, my lord. If they show us the calculation, my lord.
There is no calculation.
No calculation submission.
My lord,
The memo which is.
The directions of learned single judge in his order dated 23rd November 2023, while disposing of the writ petition, was to direct the respondents to pay the salary to the petitioners for the period from April 2013 to 8/10/2014 within stipulated time. It is the aforesaid directions which are brought under the contempt jurisdiction of this court, alleging breach thereof. In response to the notice by the court, the respondent has filed affidavit of compliance. Affidavit formed by one Subha B.N., daughter of Narayan Swami B.C., holding the post of executive engineer, integrated electric in BESCOM. What is BESCOM? Bangalore Electricity.
Electricity.
Pura name. In which it is stated in paragraph 3, thus, and bracketed portion. The complainants Gagman are supplied. वहां से लेके NEFT. Along with the affidavit paragraph after quoting. What is this page for?
Like I have, for this, my lord, is the bank transfer, my lord.
The statement of the
Page
bank
number 4 is.
showing the transfer of the amount
Yes, statement showing the bank.
is produced.
Conclusion is that they've received the amount in the bank.
Lord, they have paid the salary, the outsourcers agency, my lord.
This amount is full stop in full stop paragraph. Today, in course of the hearing, on behalf of the complainant, memo dated 20th/11/24 came to file, in which the accused has, in which the complainant has acknowledged the receipt of payment of aforesaid payment of rupees 11,62,771. However, it is claimed that the it is claimed that there is short payment to the tune of rupees 2 lakhs and more. Full stop. The complainant has not been able to demonstrate by way of producing calculations that how there is a that in what as to how the shortfall is calculated. Full stop. In the aforesaid view, the court finds that there is a compliance of the order and directions of the court in respect of payment of salary. The doctrine of substantive compliance would apply. It cannot be said that there is any willful contempt committed, even if there is a calculation error to some extent in the said amount. The contempt proceedings are therefore closed. Full stop. As far as the differential amount of rupees 2,24,857 is concerned, is claimed by the complainant, it will be permissible for the complainant to approach the competent authority with calculation and to resolve the calculation difference. Full stop. However, no contempt proceedings are required to be continued anymore. They are disposed of.
Number 45, Mohammed Tahir.
Madam, my lord, I appear for the respondent.
Who is, nobody is there?
He was there, my lord, it was passed out because I was not there. I request for a week time to come.
Somewhere in February, January, 10th January.
46.
It's also the similar matter. 45 and 46. Both.
This is bill number 72. To Satyan and the BS.
Taken in order, 58. In order of. Wait, in order of serial.
Number 58. May I please? 58.
Lords,
68, my lords, I appear for the respondent. I have instructions to file wakalat, my lords. I'll be filing the same in the registry.
Lords, is
Request a
this-
short accommodation to file objections to the application for condemnation of
Lords, if
delay,
I'm
my
not
lords.
wrong, this is item 58 and my learned colleague is appearing in another matter.
Apologies, apologies.
Please, my lords, may I please, your lordships. Lords, to put the entire issue in one line, lords, there is a reservoir, there is a dam which is specifically constructed for irrigation, but the state is using that water for industries in the name of drinking water, my lords. My lords, I will take you to 2 to 3 documents I will show to your lordships, and your lordship will see how the mismanagement of a vital natural resource is done. Lords, may please come to annexure A, my lords. At page 31, my lords, it starts at page 31, and the clean copy is at page 33, my lords. Lords, this is the 1961 administrative sanction to the same reservoir. Page 31 is the document. 33 is the clean copy.
Not legible.
My lords, the next 33, same document, the typed copy is there. May I please read the preamble, my lords?
Yes.
The Malaprabha project in Belgaum district was contemplated by the former government of Bombay and included in the second 5-year plan of the state for giving irrigation facilities to the areas of Bijapur, Belgaum and Dharwad districts which are subject to continuous visitations of famine. My lords, the entire administrative sanction explains how many acres of land is to be irrigated. And the same document, my lords, this is the continuation of administrative sanction from Bombay government to Mysore government. My lords, the same after formation of Karnataka, my lords, the respondents have filed that subsequent document. Please come to my lords R1. It is page 12 of their statement of objection. Page 12 of statement of objection filed by all the respondents, my lords. My lords, this is, if my lords has it, page 12. I need to show only one line in this. I think this is
who
very
is
illegible, but I will try to show only one
So they are
relevant
already-
line.
They are already appearing.
My lords, already.
Would have appeared, I have filed statement of objections that is answered in paragraph 17 and 18 also.
I think there is a confusion. My lords,
Who wanted to file wakalatnama?
Respondent number 5.
Who is number 5? We thought it is a fresh matter, Mr.
lords, the pleadings are complete. I don't wish to file any rejoinder to their objection.
Member Secretary Malapat.
Yes, respondent number 6.
So you are not,
And 5 and 6, I don't appear, my lord.
5 and 6 you don't. appear.
I will appear for 5. For 5, I will appear.
Who, the lady advocate wanting to file wakalatnama?
My lady friend was in different matter, my lords.
Yes, madam. Where is that? Mr. Somebody wants to file, somebody wants to.
My lords,
appeal it.
she was appearing in another 68. She got confused and she logged in 58. My lords, may I please show one line in R1, my lords? Please come to point 3, my lords. This is the extended administrative sanction to the same project, which also states that, if my lords has it, page 12 of the reply,
Page 12.
a statement of objections, my lords. Point 3. The modified project it's little troubling, my lords, but I will read this. The modified project estimated to cost rupees so and so lakhs for irrigating purpose. My lords, may please note, again, it is for the irrigating purposes. The area is extended here. The dam's elevation was extended. Immediately next page, my lords, the next annexure at page 14. Again in 2009, there is additional allocation of funds to the same project. This also states, my lords, the second paragraph in the preamble, page 14, my lords. After 1980, again in 2009, there is an additional allocation of the fund. In the preamble second paragraph, Malaprabha project has now been planned to irrigate area of 1.96 lakh 132 hectare under MRBC different irrigation projects and additional allocation. Lords, this is the paper of the state. But what the state is doing in reality, what their recent orders of 2023 speaks for, they stop the water for irrigation completely without there being any law. Not even a single drop for irrigation. They publish orders, they issue orders saying that we are not supplying a single drop of water for this entire year. And my lords, the data which are indicated in the orders, they are so apparently false, it will speak for itself, my lords. I can show the orders. Please come to their proceedings, my lords. The meetings which have decided, the meetings which have resulted in non-supply of irrigation water. The data, my lords, if my lords see at page 39. Lords, there is, in fact, out of, if I have to say it fairly, my lords, there are industrial forces which are playing against the interest of the farmers. This needs to be answered, investigated, my lords. Lords, at page 39, my annexure B, my lords, to my petition. These are the proceedings dated 5 August 2023. In this meeting, my lords, they decided to stop water for irrigation. If my lords has it, page 39, my lords. From 38 it starts and the second page, 39.
So they are releasing for irrigation also.
My lords, I will show it. I will show it how they are arbitrarily deciding what portion of water will be sent to irrigation, what portion of water will be used for drinking water. It has become a gambling of forces, my lords. There is complete lawlessness. And I will also show what is the statutory right of the notified farmers, my lords. There is a Karnataka Irrigation Act which says what rule is to be followed. The act is thrown in air.
They are arbitrarily deciding what? The quantum of water. Quantity of water.
My lords, for irrigation, there is zero. For irrigation, there is zero. I will show it to your lordships. At page 39, my lords.
Page?
At page 38, there is a table showing comparative water storage for the year 22 and 23. At page 38, my lords, if my lords has it. My lords, if, there is a comparative chart for 22 and 23.
No.
At 38.
Same.
Annexure B, my lords. There is a typed copy. I have annexed a typed copy. There is a table, my lords, which shows that the LC column is useful water. LC. Lords, this column shows as on 5/8/2023, there is 17.793 TMC. Previous year, it was 23.133 TMC. My lords, please come to the adjacent page 39, my lords. The calculation for total drinking water requirement is 17.106 TMC. My lords, this is in August. After lapse of 1 month, by all the means of logic, this demand has to reduce. The people already drank water for 1 month. The demand has to reduce, but their data shows increased demand. For a lesser period, the demand for drinking water increased. This is a cardman's mathematics, my lords. There is no basis for this. There is no, in fact, there are institutes which do water budgeting. They analyze the demand. They give the quantum to be fixed. But for this calculation, there is no number, there is no basis, nothing at all. In August, the demand is 17.106 TMC. If my lord see the next proceedings, in September, it becomes 17.2 TMC. By lapse of time, the water required is, it has to get lower and lower. If my lords come to the annexure E, my lords, page number 62, my lords, I will also point out that error in the data which they have recorded in the proceedings. Page 62, my lords, it starts from 61, proceedings dated 29/2023, after almost 2 months. My lords, page 62, total probable drinking water requirement 17.2 TMC. After lapse of 2 months, the demand for water has increased. I will also show where the calculation went wrong. My lords, may please note point 2. In the above calculation, point 2 for Saudatti, Bailongal, DBOT and other multi-village schemes, here they have decided to release water of 70 cusecs per day. In previous proceedings, this quantum of release was 50 cusecs. The difference of 20 cusecs is arbitrary, it is baseless, without any recommendation. Page 62, my lords.
Page 62.
Page 62, my lords. My lords, may please note the total water demand and also please note the second column. Here they have increased from 50 cusecs per day to 70 cusecs per day. And now, my lords, I will show the law. If my lords may please have the Karnataka Irrigation Act, I have annexed the relevant provisions in my appendix, my lords, at page 28. At page 28, my lords, I have annexed the relevant provisions of Karnataka Irrigation Act. My lords, section 29. May I please read, my lords? Section 29, my lords, Irrigation Act 65. My lords, the supply of water to any field channel or to any person who is entitled to such supply shall not be stopped. This gives the statutory right to farmers. Authorities cannot arbitrarily say that we are not leaving the water, we are stopping the water, we are releasing the water. It's not their arbitrary decision, my lords. There is an act which governs. This act is quoted in the proceedings, but for different purposes. Only to penalize the farmers, they rely on this document. Not for the benefits the farmers are entitled to out of this same act. I can show that this act's provisions are referred to in the proceedings to take criminal prosecution against the farmers. But when it comes to the rights the farmers have, they forget about the act. Not even a single provision mentioned under what provision they are not releasing water for irrigation. My lords, again, the respondents are saying that the committee is formed. The committee, what they are referring to is statutory committee. That's not my prayer in this petition. My lords, that is the Irrigation Advisory Committee, which is a duty of the state to form every year or every recurring period. But in fact, they have not formed earlier, and now they are showing that this committee is formed. That's not the committee what I want. That committee can only budget and decide the utilization of irrigation water. My lords, there has to be a super scheme which allocates the water for different purposes. The priorities are fixed, my lords. The priorities has to follow a table of drinking, then comes to irrigation, then comes to industry. There has to be a scheme which will analyze the total capacity, which will allocate for different purposes. That's my submission, my lords. And for that sake, my lords, the utilization of water from this dam for industrial purpose is nowhere shown. Their data is completely silent. But it is evident that in Hubli and Dharwad cities, there are 3 industrial areas operating. Very adjacent to the dam site, there are sugar factories. My lords, the Belgaum district is known for sugar factories. Not even a single drop of water is shown for industrial purposes. My lords, the intent of farmers is to know the truth and to get what they are entitled for. That's my prayer, lords. Every year, thousands of crore is spent on renovation, extension of canal networks, which lie unused for next subsequent years. Again, they will be repaired. The canals are only meant for the purpose of repairing, my lords. In fact, these farmers are notified as irrigated farmers. Lords, they are ousted from the benefits of rain-fed farmers. They will be considered as irrigated farmers. In actual, they are not irrigated by these projects. In fact, the Honorable Supreme Court also realized about the right of farmers for utilization of irrigation water, my lords. I have also annexed the relevant paragraph of the judgment in my appendix, which states that the farmers have right in utilization of the irrigation water.
Yes, madam.
My lord, my lord, the proceedings that have been produced by the petitioner, my lord, if my lord were to take page 28, my lord, the reason why a decision was taken, my lord, to supply water was because there was scarcity of drinking water. My lord gets translated a copy of annexure P2. It is at page 28. The last paragraph, my lord will get it, the last sentence. The probable drinking water requirement. My lord, before that, as on 5/8/2023, the water level is shown in the table, page 28.
Page 38.
My lord, no, 28 of the writ petition. Huh?
It is 38, B1.
B, 28, my lords, 28. What my learned friend is referring to is page 28.
28 is something else. The house is not in order.
My lords, the annexure B, 28, there is a comparative chart which
That is
the lordships
38.
have referred.
You said it is 30.
There are two charts, two different proceedings, 1.5 months.
Page 20 is appendix, then state of
My
Maharashtra.
lords, 38, I'm sorry, 38, my lords.
38 is a chart, table. The latter part of the page.
My lord, then let my learned friend give me a proper copy and I will argue the matter.
That's better.
Please, I will supply.
Welcome to Bangalore again.
Grateful, my lords.
When do you want?
Lords, all the indulgence I may seek is, my lords, may allow me to appear through VC, my lords. I traveled from Delhi for this specific matter. I have concluded all my submissions. It's all left to my learned friend. I will supply the neat copy. My learned friend may, whatever they wish to convince your lordships, it's left to them.
So, learned advocate for the petitioner will supply a copy of the set of the petition, properly paged to learned additional government advocate, Ms. Nilofer Akbar, within 2 weeks.
Please, I'm ready.
Send over to which date?
Whatever, except Monday and Friday, whatever date your lordships are convenient.
18th of December.
I'm grateful, my lords.
Obliged.
I may be permitted to appear through VC, my lords.
No, my lord, let him have the pleasure of coming and opposing.
I'm grateful, my lords. I will take that opportunity, my lords.
Sorry, my lord, I took the liberty.
Number 72.
No. 611, the Lordships had directed me to produce May I request your Lordships to see the orders dated 611.
So, your filing? So this is the same matter where you are arguing that amount was paid?
Yes, this is the one.
Some amount, so part of the amount was paid?
Yes, my lord, what had happened is a submission was made by the respondent's counsel to the learned arbitrator saying that during the pendency of civil miscellaneous petition before this court, an amount of 3.5 crores have been paid, have been deposited to my account.
3 point?
Please, my lord.
3.5 crores.
3.5 crores. That your lordships, my lord, will get it at, my lord, in page 56.
Page?
Internal page 24 of the award.
Internal page, my lord, 24 of the
24.
award. Of the award. Once.
And
Make my submissions.
and this
Please.
is, yeah, this is, no, I'm just helping you, sir. This has also been recorded.
46 is the
Internal page 24, ground C.
24.
Ground C.
Yes.
Ground C.
So
No,
clarification
not that.
submitted are as follows. So this clarification was given by you. Ground C is by you.
No, ground C is my statement which has been recorded about this 3.5, but I'll come to that later. Let him finish.
You are Gumre.
Yes.
Submits that about a sum of 3.5 crores credited to the account of. So this is kind of an admission,
No, no.
acknowledge.
No. Let him finish. I'll distinguish.
Lord,
it.
page 84. Page 84.
Yes.
Internal page 24. Ground C. This was the statement made by the counsel, that is Clement, my lord, to the learned arbitrator. Now, my lord, if my lords may kindly turn to, my lord, page 95. Internal page 35. Seven lines from the bottom of that particular paragraph, 81. Learned arbitrator, my lord, records a finding, my lord, that no document is produced to show that 3 crore rupees has been paid towards full and final settlement. That apart. Fact remains, my lord, I had paid an amount of 3.5 crores, even according to the statement made by the counsel for the respondent. If this, let us assume for argument's sake that whatever claims here made and approved by the learned arbitrator is to be considered as true, I am entitled for a deduction of 3.5 crores from that. Thereafterwards, my lord, if at all there is some discrepancy or if evidence is not taken into consideration, my lord, then that has to be worked out. Now, here is a case where, my lord, this amount, though a statement is made, this amount is completely ignored. And then, my lord, I have been saddled by your lordships. In fact, on this ground itself, the entire award, my lord, has to be set aside. Kindly see, your lordships have directed me to produce the document showing that I had made payment of 3.5 crores. I have produced today, my lord, these documents before your lordships. I have made out a statement.
So what is the total award?
My lord,
Awarded
total
amount?
award, this is where, my lord, I have produced a statement before your lordships.
Total awarded amount.
Total awarded amount, my lord, kindly turn to page 20 of today's memo, my lord.
No, as per the arbitrator's award.
Yes, I have culled out everything here. Page 20, that is the last page. Second item.
Yes.
As per arbitration award, total amount is 4 crores 90,15,391. Then, my lord, whatever amount, my lord, is paid by me is 3 crores 54 lakhs 25,608.
It was paid.
That is the amount, my lord, which my learned friend says that it has been paid.
And you are saying you are paid.
Yes, and to that effect, I have produced documents also today before your lordships.
No, that page 129 is the final award. Page
That
one.
is, yes, that is the final award. My lord.
So
My lord,
total,
what happens is, learned arbitrator, my lord, has
all
there were
amounts in 1 to 10 awarded comes to rupees
4 crores
4 crores.
90 lakhs 15,391. Added to that, interest at 18% from 2019. In fact, this amount of 3 crores 54 lakhs, my lord, has been paid by me on 28/2019 itself. In my petition, my lord,
It doesn't make total of 4 crores.
my lord, what I have done is, kindly see, if my lords, I can point out this from the top statement of one case.
So first is 34 lakhs, second is 10 lakh, third is 26 lakhs, 4 is 50,000, then 7,000.
My lord,
3
here,
lakh
I would like to say here,
with interest.
may I
at
request your
18%.
lordships to kindly see 8th column, my lord, in that statement, my lord, page 20 itself,
8, yes.
page 20, 8th column, as per arbitration order.
Oh,
Yes, if I add up this, an amount of 40, my lord, 4 crores 90 lakhs, grand total, 4 crores 90 lakh 15,391. My lord, what happens is that commas, my lord, probably is confusing. In respect of various wards, 12 wards, my lord, I had called this tender. Tender for, my lord, main construction and maintenance of.
No, we are trying to understand that
Please.
the operative portion of the award.
Please, my lord.
Is at page 129. Various sums are awarded in Roman 1 to Roman 10.
Yes,
including 18% interest.
yes.
It doesn't calculate to.
My lord, 129, what has happened is, kindly appreciate this. What has happened, my lord, is this. Each of the case numbers, learned arbitrator has taken it up. This is the last case number, amount what has been arrived at. My lord, kindly see, it starts, basically the calculation starts from
How many cases?
108.
How many cases are there?
12 cases were filed by them.
That is a different, all right.
12 cases were filed by them.
So this is
My lord, all the cases were clubbed. This confusion has arisen in this regard itself. 12 cases were filed by them. Various amounts were claimed under different heads.
So according to you, out of 4 crores 90 lakhs, 3.5 is paid.
3.54 is already paid by me. At best, let us assume that this amount is correct. That is 4 crores 90 lakhs is correct. But I am entitled to pay them 1 crore 35 lakhs itself. That is the only amount which I am supposed to pay. And this amount of 3.54 crores, my lord, was paid by me on 28/2019, while interest, my lord, has been awarded by the learned arbitrator at 18%, which though I am not liable to pay, my lord, from the year 2019 itself. So when the amount, my lord, is already paid by me, substantial amount is already paid by me, that amount not giving appropriate credit to that amount from the amount which has already been arrived at. But there is a specific, my lord, there is a flaw insofar as this award itself is concerned. On that ground, my lord, when I bring it to the notice of the learned 34 court, my lord, ought to have exercised his jurisdiction, my lord, ought to have looked into it. Absolutely no finding on that at all. No finding.
So according to what is next?
Please, my lord.
According to you, what is next?
My lord, in which event, my lord, I place reliance on 2 judgments. My lord, one judgment of this court, that is division bench of this court, my lord, on an earlier occasion where this court, my lord, has said the section 34 appeals, petitions, my lord, cannot be disposed of by a cryptic orders by saying that the view taken by the arbitrator is correct without even application of mind. My lord, that is exactly what 34 court has done. He has extracted, my lord, the case of the complainant, case of the claimant, respondent's case, then arguments, and then finding saying that the arbitrator's view is correct. That is where, my lord, this court, my lord, and the Honorable Supreme Court also, in these 2 judgments, my lord.
No, we are asking that
Please,
if you are right, then what is next?
I only say this, my lord. From this amount of 4 crores 90 lakhs.
What is the next course of action on our part, if you are right? That is what we are asking.
The entire award, my lord, has to be set aside. And this section 37 appeal, my lord, request to be allowed. Or maybe a remand order has to be done.
Can that be done?
Please, my lord.
Can that be sent back?
It has to be sent back to the learned 34 court, my lord, where, my lord, learned 34 court has to appreciate apart from these aspects, because 3 items, my lord, which I had denied. My lord, I realize that there is some mistake from my side. I constitute a committee. I say that these amounts, I am supposed to pay them. Kindly see the statement, 9th column from that particular, in the statement. This is the amount which I have paid them. And now learned arbitrator says you repay that same amount. Kindly see the 9th column.
So this is paid by what means? By
RTGS transfer.
RGTS.
Yes, I have produced the documents also before your lordships.
Yes, what?
Please finish then. The completely misconceived appeal. My learned friend, with great respect, doesn't know as to what are the facts of the case. There are 2 sorts of amounts. One, bills, one claims. On the same page where my statement is at C, if your lordship just come to 52F on page 25. 85. Yeah, 85 is the running page, but 25 is the internal award. F. The learned arbitrator at that point of time had specifically, have your lordships got it?
85.
Yeah, running page 85, 25 of the award.
Yes.
The learned arbitrator at that point in time wanted to have clarifications on certain issues. Therefore, he specifically called for a hearing on those issues. And then at sub-para F, he asked about this 3.5 crores because about this payment of 3.5, 3.25 or 3.5, whatever, those were amounts of bills, not of the claim. And therefore, there is a statement made on behalf of BBMP, the appellants, Mrs. Bindu Shri appearing for the BBMP. I'll just read. If she submits that the claims made herein are not covered by the payments by the respondent to the claimant. She also submits that no amounts whatsoever is received by the claimant towards the claims made in these petitions. So those claims were completely separate. Then this is their own statement which has been made.
Probably this is a wrong statement. I can only say this. Lord, they don't have any other claim. If they were to have any claim, they should have raised it before the learned arbitrator.
What sort of
Kindly appreciate.
According to you, this amount is towards what?
This amounted towards construction. I'll just
No.
Now if my learned friend wants to argue, let him argue to its
Bill,
heart's
bill.
content, then I will.
Bill. According
Yes,
to
yes.
which bill?
How it was. There were in these 12 locations, certain constructions were to be made for the purpose of biofuel. So the construction aspect was separate, and then subsequently operation and maintenance was separate. It is towards these, there were milestones which were given that on the completion of a particular milestone, certain amounts were to be given. That was purely in terms of construction. Now, during the course of this award, I'll show it. In 10 locations, these plants were complete. Hence, complete payments were to be made. And in terms of 2 locations, first milestone had been achieved. So therefore, payments in terms of 2 milestones were only made, in terms of 2 projects were only made in terms of 1 milestone. These payments were towards the bills which were pending towards the construction and not towards the claims. Hence, this statement was made, and the learned arbitrator had specifically asked for this. Now, my learned friend, number 1, cannot come now and say, I don't know what sort of argument would this be, that the statement over there is wrong. The statement is there. It's a very clear statement, categorical. Therefore, when these claims were filed, that 3.
If it was a separate, then separate and distinct from the claim.
Yes.
What was the reason for you to make a statement?
That 3.5 crores had come towards part of construction and not towards claims. The claims,
It is according to it is of no relevance.
Yes, it was over there.
You are saying that payment of 3.5 crores is of no
relevance here in these claims.
Correct.
Because, yes,
So then why you made a statement?
the learned arbitrator asked as to when these this amount was received by you. Therefore, we said that after the CMP was filed, hence the 3.5 crores of the bills pending came to us. That was the only.
No, that is not the statement made by them.
No. Next
That is
statement
not the statement
in
made by
F
them.
very clearly
Very
says.
unfortunate. Lord, I can only make this statement, my lord. Kindly see this. If my lords may kindly see this particular statement made by the learned counsel. He never says that this amount is received by me in respect of those bills, so-called bills are concerned. He makes a simpliciter statement saying that these amount of rupees 3.5 crores has been received by us during the pendency of CMP filed before this court. Then in which event, my lord, it has to be presumed that it is in respect of these claims are concerned. Admittedly, my lord, let us assume for argument's sake that, my lord, the bills were also not paid to him. If it were to be paid, my lord, in the year 2019, where is the claim to that effect here? Kindly see the claim petition here.
My learned friend only glosses over the statement.
My lord, kindly see
of F, that is of
No,
the
no, it is not like
learned
that.
counsel appearing for the
Probably-
corporation, where she categorically says that this is not a part of the claims. What more clarity should be gotten from the arbitrator?
And there is
has
no
considered-
finding also to that.
It is a word against word. You are saying it is not part of the claim. They are saying part of the claim.
Yes.
No, but when I say, when the statement is recorded as far as 3.5 crores is concerned, it says that we've only got it. We do not say that these are covered by claims. But the crucial difference is the BBMP says that these are not towards the claims.
Let the records be called for from the learned arbitrator, from the arbitration center, let the records be called for. My lord, this exercise ought to have been made by section 34 code. 34 code does not deal with this. That is where, my lord, these two judgments are placed.
What is the statement we have, this summary of online payment transaction?
Yes. Online transfer which I have made, that is a summary which I have given along with the document showing that the amounts have been paid to them.
My learned
All
friend,
amount.
Yes, all amounts.
All amounts indicated in tabular form.
Yes, yes.
Paid through RTGS.
Yes. And to that extent, my lord, I have prepared a statement also.
learned friend is completely misdirecting and taking it towards a different aspect. The 3.5 crores, there is no dispute that an amount has been received.
Lord, they have
But-
misled
but
the learned
dispute-
arbitrator like anything.
If he wants to keep on interrupting, let him finish his pleading. I will then subsequently address your lordships. That is the way of.
Yes.
So, when the bills for construction were there, hence those were not included in the claim petition. And that is what is being recorded in F. The learned arbitrator very categorically questioned, and therefore, please look into as to what is the statement which is made. She submits that the claims made herein are not covered by the payments made by the respondent to the claim. What more clarity? And then she further submits. She also submits that no amount whatsoever is received by the claimants towards the claims made in these petitions.
That's all. That's the only compass of the controversy.
I beg your pardon?
That's the only area of controversy.
That's the only and
Area
then
of
second
dispute is only to
aspect
that.
I want to, when my learned friend canvasses that the learned section of district court in 34 should have looked into all of this. In 34, there is no ground, and I specifically say there is no ground by the appellants herein about this 3.5 crores.
It is
37,
It is there.
please look into the grounds. 37 is an appeal essentially only from 34. It's not an appeal per se in the regular. So there's a ruling of the Supreme Court on that. So the position is quite clear. So unless and until there is no ground in 34, that cannot be canvassed. And this statement, in fact, very categorically, the learned arbitrator called for all of this. And then he had a special session for this. So my learned friend in this limited scope of 37 is trying to canvass a completely different and alien case, which was not their case even in the arbitration or in 34. That cannot be permitted over here. If this sort of arguments are gone into, then the entire process, and let me finish, then you can, then there is the arbitrator, as per almost all the courts, is the master of facts and the master of evidence. When the learned arbitrator clearly records, because he was aware, and hence he asked us, have you received those payments? And then he asked, what is the nature of the payments? And therefore this statement came to be made, which is very clear when they categorically state in two different subparts of the same statement that this payment is not covered by the claims.
So according to you, they are the construction bills.
Yes, this is construction and claims are different. Otherwise, those could have also been added over here that these bills are pending. But that is not the case.
May I submit, my lord?
For you, anything to show that it is reverse claim?
Please, my lord.
Anything to show that these amounts paid by you amounting to 3.54 crores is towards the claims.
Yes, it is towards the claim. Kindly see this. Kindly see page 37 for a minute.
Page 37.
Page 37 of the appeal memo, which I have filed. Kindly see the claims, my lord, made by them. Lord, admitted fact is 3.54 crores is received by them on 28/2009. Please, my lord, kindly see these claims what they have made before your lordships, before the learned arbitrator.
Page?
Page 37. It starts from page 37 in respect of various wards are concerned.
Yes, awards are concerned.
Yes.
So
Lord, in AC 76 of 2020,
yes.
my lord, the claim made is 13.39 lakhs in respect of compensation for shortage in the supply of waste.
True.
Then, my lord, claimant is entitled to a sum of 10.22 lakhs for idling of manpower, plant and machinery. Then, my lord, 3.15 lakhs in respect of reimbursement of expenditure. Then, my lord, 50,000 towards the from the respondent by way of return of fine. Then 3.16 my lord towards water and power supply. Then 18%. My lord, this is in respect of 76 is concerned. Likewise, my lord, 77, 78, 79. Kindly see 77, 78 they are asking for, since the project did not go through in respect of 77 and 78. They asked for 11.85 lakhs and that amount is also given to them. Now, my lord, if as on this date, the dispute which was raised by them was in the year 2016. Kindly appreciate this. They gave a representation to me saying that this is the only dispute that is pending consideration. If really the dispute, my lord, regarding bills, non-payment of bills were to be there, then they ought to have raised this particular issue in the year 2016 itself. In respect of so-called bills, non-payment of so-called bills, my lord, they did not raise any dispute. Their claim was only to this extent. Total claim based lodged before the learned arbitrator was 37 crores against me. And this is the representation what they gave to me, saying that I am entitled for 37 crores on various under various claims, saying that idling of manpower and then water and power charges, and then, my lord, so many other clauses what I read out to your lordships. And admittedly, my lord, I made this payment on 28/2019. There was a dispute if there were to be, if as stated by my learned friend, if he says that it was towards the bill, why did he receive it in the year 2009, my lord? Then my lord, in so far interest is concerned, it's a tender pursuant to a tender which has been given, my lord, as interest is concerned. And this payment, my lord, is made by me in the year 2019 itself. In fact, learned arbitrator, my lord, 18%. There is no basis for this 18%, fixation at 18%.
Supreme Court in MR Shah, Ingenious, there's a concept called as doctrine of incorporation by reference, has relied on that. And the Supreme Court says that there are two instances. I can produce those because we have produced it, and which has been recorded by the honorable arbitrator. Because early on, the arbitrator was also of the view that interest cannot be granted. But when certain set of letters which were shown, the concept of doctrine of incorporation by reference came into play. And that is when the learned arbitrator said, yes, 18% has to be granted, because one of the, now let me finish. My learned friend is taking this to a completely different direction, and there are misrepresentations, if I may say so. So therefore, the learned arbitrator in his award has relied upon MR engineers and has then granted 18% because in one of the letters, it was that 18% interest should be incorporated. Subsequently, in another letter, which was then returned to the chief engineer, this letter in which there was 18% interest, which was referred to, has been incorporated. And therefore, the Supreme Court says that there are two instances in which documents can be taken into consideration. One is when the entire document can be taken into a reference when the document is referred to. And one is about clause of arbitration. So MR engineers clearly distinguishes on that factor. It's squarely and directly covered by the judgment of the Supreme Court in that particular matter. Hence, 18% interest came into play and was awarded. Secondly, as far as this 3.5 crore, there is a stark contrast between the statement made at subpara C and subpara F, wherein there is a categorical admission by them. 3.5 came in, that's not an issue. This was not covered by the claims, which is the stand of BBMP. How can they run away from their stand? And now, in 37 claims, and therefore that needs to be deducted. That's not the case. And then when they come into 34, the grounds. I'll just address the grounds in 34.
Mr. BBMP Deep showing some work orders.
Yes, fair enough.
So those work orders may give the details about what kind of.
No difficult. That was a part. All has dealt with that. Hence, he came to this clarification.
So kindly appreciate this.
Therefore,
this work order, whatever. Now, kindly see column number 1 in that statement, which I have produced before your lordships.
Correct.
At today's statement. No, page 3 may kindly be seen for everyone of today's.
3 also there.
Yes, 3 also. It says job. What is that nature of the job? Then work order number is given. Whatever happens, my lord, it happens in that particular work order.
Correct.
Suppose if I am paying any amount as damages or whatever it is, it has to go under, your lordships is very well aware of that. That is where, my lord, I have simply stated that as a work order, and what is that work order under which I am doing it. This amount, my lord, is paid towards this particular ward is concerned under the work order number.
what my learned friend.
That is where, my lord, I've been saying this. 1 second.
The entire proceedings at that stage, which is not permissible in 37, apart from the fact that there are two clear statements. Our clear statement in subpara C is that yes, 3.5 has come. We have never said that these came in towards the satisfaction of the claims or part satisfaction, whereas they categorically say in two aspects that this is not covered by the claim and this is not come for the claim. But that's a clear admission. Had this been a suit under 12.6, this could have been judgment on admission.
Very well.
Para F, 52F, page 25. So lordships may see page 24 and 25 both, just to have a contrast of
that we have seen C and F.
yes, C and F. So there's a categorical submission. She submits that the claims made herein are not covered by the payments.
Probably, as said, my lord, it is word against word.
No, it's
My
not.
lord, I have produced a document to show that, my lord, an amount of 3.5 crores has been paid. It is double taxation to me, my lord, insofar as the same claims are concerned.
Wrong submission
No.
which is coming in, that is word against word from my learned friend, because there is an admission in F, whereas there is only assertion that yes, 3.5 crores has come in.
He should have clarified this statement, saying that this is not in respect of these claims are concerned, it is in respect of bills are concerned.
BBMP themselves have clarified that this is not a part of the claim. What more is required on this single aspect? This 37 should go. And even in 34, may I tender a copy of their section 34 application?
86. 86.
Page 87 of their section 54 application. The grounds start from there. Page 86 is from where the grounds start. Page 86.
Page
86.
86.
86 is where the grounds start, because 37 is essentially an appeal on 34. I'll just take your lordships through. There are only 5 or 6 grounds. There, 34 application. They've never said that 3.5 covered these claims and that these should have been factored in. Apart from the fact that the statement in subpara F is there, I'll just take your lordships. So grounds 21. Honorable Tribunal grossly erred in observing that breach of contract is committed by respondent BBMP. It ought to have the appreciated that delay in commencement or completion of.
Need not read, because you are saying that there is no such ground about.
There is no such ground. I'm just putting forth, but otherwise there is no ground.
And then this is the factual aspect to be examined, whether ground or not. Something factual is asserted.
Yes, so there is no ground. It has to be addressed to. As far as 18% is there, yes, they have addressed it. At any rate, the rate of interest awarded at the rate of 18% is high.
So for orders on 6th of December.
6th. And I'm grateful that your lordships accommodated me.
I have placed 2 judgments on record, my lord.
Whatever you want to place within 2 days.
No, I have already placed it
We'll
before
also
your
place some
lordships.
judgments. We'll also
Only
place some-
thing is, my lord,
Yes, yes.
my lord, I have disputed 3 items, my lord, which I am supposed to, which the learned arbitrator, my lord, has imposed on me. Those 3 items, my lord, which learned 34 court ought to have discussed on these aspects. 2 judgments, my lord, which I have stated, which I have placed, my lord, saying that the grounds, my lord, ought to have been discussed, and then cryptically it cannot be para 12 and onwards. And another judgment, my lord, of the Honorable Supreme Court.
You produce the.
Would your lordship permit me to allow appear on DC?
Now, there is no argument.
Yes.
Please. The interim undertaking, my lord, has to. Please.
We are simply saying stand over to 6th of December. The order passed earlier. It already contemplates the stay of the execution.
My lord, they had given an undertaking before your lordships.
No. There's some, let us see, where is that order?
611, my lord, they had given an
611,
undertaking.
611. So observations in paragraph 4 shall continue to operate.
Please.
Till the next.
Please.
Shall continue to operate till till the next.
Please.
Till number 108 to Chandan K.
Same matter. 101. Live. This writ petition was posted on board yesterday from a learned advocate. Mentioned the same for taking up out of turn, showing the urgency. It could not be taken up for want of, for paucity of time yesterday. Full stop. The court, comma, in view of the request made, comma, kept the petition today to be taken up in second session. It kept today, full stop. When the petition was called out, paragraph. In the second half, out of turn, it is out of turn.
Yes.
Out of turn, none was present to conduct the petition. Stand over to.
Pardon, my lords, is it serial number 108, my lords?
Yes,
My lords, I'm appearing for the counsel for the petitioner, my lords.
so come physically, why you are online? Here
Uh,
yesterday.
Yes,
you
my
were
lords,
here.
yesterday I was there, my lords. I came all the way from Andhra Pradesh High Court for that matter. As your lordships is directed, the matters to be listed in the next week. So under a presumption that I have left to Andhra again.
you
So
will
my
come
lords, so please just kindly have it on tomorrow or day after tomorrow. I'll come, my lords.
Tomorrow it can be taken. Tomorrow.
Tomorrow, indeed, my lords.
Tomorrow, day after, whenever you want.
Whenever your lordship's convenience, my lords, I'll appear.
Your choice now.
Let's day after tomorrow, my lords.
Day after.
Deeply obliged, my lords. And I sincerely apologize, my lords, because of the technical issue. I couldn't hear the serial number.
Day after.
Deeply obliged, my lord.
Till number 110 for withdrawal of contempt. Lakshmi Narayan.
For the count, on behalf of the complainant. Sir, there's a memo of withdrawal.
Memo dated 24/10/24 figures on record of these contempt proceedings, in which the complainant has submitted that accused that the respondent has complied with the order, therefore he may be permitted to withdraw the contempt petition. Permission is granted, dismissed as withdrawn. Please.
Number 111. Chetan K. 111.
Withdraw. Withdraw. Figures on record, memo dated. Memo, which is undated, in which filed by learner of the appellant, in which it is stated that the appellant is not desired to proceed with the writ appeal. And sought permission to withdraw. The same, permission is granted, dismissed as withdrawn. Writ appeal is dismissed as withdrawn.
This is 112, G.S. Venkata Subbarao.
Lords, in this matter, I have submitted last day. But the amendment has been carried out post not the judgment of the learned single judge. Pursuant to the amendment, please note, fresh amendments have been made. They have been challenged subsequently also. This my lord's contempt would not survive.
However, my lord, the matter, the order, my lord, as it is stands, there are other two, my lord, contempts, my lord, which are pending, my lord, arising out of the same orders. My lord, the contempt, my lord, the petition number 954 and 955.
Amend, please, lords, the DBMP Act. DBMP Act was amended pursuant to lords, the orders issued by the learned single judge.
In fact,
Fresh demands have been made.
he said that, my lord, he would
That
place
is-
it on record.
It is also-
He said he will place it on record, my lord, that is not so. See, arising out of the same directions, my lord, two contempt petitions are already pending against the same accused. My lord, 951, 954 and my lord, 955 of 2022. 22. Please, let this go with that. Yes.
Now, the fresh amendment, please, not fresh demand is made. That is also under challenge. Now they are reserved for orders.
However, my lord,
This is prior to the amendment.
that does not take away these directions. That doesn't take away these directions unless, my lord, he shows it.
It was stated by learned advocate Mr. So-and-so with the complainant that two other contempt petitions, which is CC number 951 and 951 of 2022.
Please.
And 952 of 2022.
954 and 955.
4 and 5, arising out of the very order brought under contempt jurisdiction. This petition are pending. It is right, therefore, that all the three contempt petitions are heard together. Full stop. The registrar judicial is directed to place the matters for approved orders before on administrative side.
Great.
$113, Vaishali Hegde.
What is the urgency?
Please. The exams, your lordship, are due, are to start on the 2nd of December. But in the meanwhile, my learned friend has filed her objections in which she has placed on record the attendance, the percentage of attendance. In view of the same, your lordship may kindly take page 24 of. Of course, the attendance have been calculated from December 2023 and not from February 2024, when the supplementary students were allowed to attend the classes. She was allowed to attend classes pursuant to the interim order granted by this honorable court. So, but however, the university has stated that she falls fairly short of the required attendance. Page 25, 24 and 25.
From April to September.
Please, your lordship may kindly see total classes. This is from December 2023. The 112, 154, etc. is from December 2023. Her attendance starts from 10/4. That's the date when she got her the interim order. So if you're going to calculate from December, it's going to be short. There is no question about it.
No, the last tabular form on page 24.
Page 24, please.
The tabular form. in the
Please, your
last.
lordship.
So it calculates from 10/4/24.
10/4, see, your lordship may kindly see 112 are the number of classes taken from December 2023. 10/4 is when she got her interim order.
So these are from December 23, according to.
Please. No, it is even according to them.
The pendency of the petition before the learned single judge. So she was not entitled to progress to the next class because she had not cleared.
she was permitted by way of an interim order to attend the classes of the second year. The learned single,
Interim order was passed on when? For 10 for.
when the writ petition was pending, when she was yet to pass her exam, clear her examinations. Therefore, an interim order was made, subject to the outcome of the writ petition, she may be permitted to attend the classes, which she attended for 3 months. While dismissing the writ petition, the learned single judge specifically records that the interim order which was granted, which was contrary to the express provisions, get dissolved and she is not entitled to that benefit. Thereafter, she appeared in a supplementary examination and she has passed now. She has passed and she is entitled to progress to the next class from the date when she has passed. She has hardly attended 2 months. It's a 1-year course. She has to attend the minimum of 1 year before she can take the examination for the second year. She can't say that I have had the benefit of 3 months previously and I have attended 2 months while the course is of 1 year. The very notification under which the examinations have been notified, the very first clause says you must have a minimum attendance to take the examination. So she has to attend the class and then take the exam.
Is yours.
The mandates of law, my lords, I can show it if it is necessary, but I don't think my learned friend disputes these facts.
If that's the case, Your Lordship, my learned friend, the affidavit states that she may be permitted to take her exam in September 2025.
Yes,
That may be
is-
recorded, Your Lordship.
That is when she completes 1 year. Provided she attends the class, she can't take the examination without attending the class.
She will attend the class.
She'll attend the class. September 2025 is when they've said that she
Of
can
course, she
take
is
her.
entitled to as of right. Having,
No,
let's if
because-
she were to attend,
No, the reason why I'm saying that, sir, is because she says December.
it's May.
So we'll record your statement.
That's okay. It
Both
May,
state.
may I make one submission.
Ah.
This writ appeal is against an order of the learned single judge who says, because you are in the new regime of the NMC, you are not entitled to the gracing. That's the main challenge in this writ appeal. However, since she has passed in a supplementary examination subsequently, apparently she is not taking it forward insofar as this appeal is concerned. In this appeal, she wants a direction from this honorable court, which is a separate cause of action, which needs to be examined with reference to the number of days she has attended, eligibility, etc. I have no quarrel if, I have no objection if she is permitted to appear in the next examination once she achieves the requisite attendance, because that's the law. But the scope of this appeal has come to an end, because the only question, my lords, that is raised before this honorable court is that she is entitled to gracing. That the learned single judge has recorded finding that the old regime permitted, the new regime doesn't permit. It is under the new regime, she has now passed. So she has to go back if everything gets upset, but even assuming she succeeds in this writ appeal. Therefore, your lords may close this writ appeal, your lords may record our submission that as and when she completes the minimum requisite attendance for the second year, she would be permitted by the university.
You've stated on affidavit, sir, that it's on September 2025. Page 10, the responding university by his reply dated thing, have stated that the appellant is eligible to appear to the second MBBS exam tentatively being held on September 2025. That's all I'm requesting.
By then, in accordance with law, she would possibly complete 80% of attendance, provided she attends the class. We have no difficulty, my lords, as long as she satisfies the requirement of attendance to appear in the immediate next examination, which is conducted by the university. She can't pin us down to the date of 25th September of 2025. Because the date is only a tentative date, my lords, which is indicated in the affidavit.
A group of petitions were filed.
Please, Your Lordship.
Several petitions had filed petition.
Several petitioners.
They were all dismissed, my lords. Only
regarding-
this person has come up in appeal.
No, that's because
The
the
main appeal, my lords, is only on the issue whether she is entitled to the old regime or the new regime. In the old regime, there was a provision for grazing. In the new regime, there is a provision, no provision for grazing. It's been consciously removed by the NMC. So therefore, she is not entitled. Now she is accepting probably because she has passed under the new regime during the pendency of this writ appeal.
batch of petitions were regarding revaluation. There were several issues raised. I was the only petitioner seeking for a grace mark.
Where is the interim order?
Please,
Interim order passed
in the, I have passed.
You passed last time, but. No, it is, yes, this is for. No, there is no. Okay.
You got another copy?
We'll pass the orders recording the subsequent development and the statement that
Kindly see, my lords, page 86 of the order of the learned single judge. He has dissolved the interim order which was made. The my lords, provisions expressly prohibit progressing to the next class. However, an ex parte interim order was made, which the learned single judge says it is dissolved because the writ petition is being dismissed. I have no difficulty assuming that she is entitled to benefit of 3 months which she has attended, provided she completes the requisite attendance in the second year.
she is saying that on September 24th, she will appear.
Yes,
September 25th.
September 2025.
We have no next exam. Your lords may not say September 25.
They have mentioned it in, I'm reading from their affidavit.
Whenever, my lords, the examination is conducted.
Correct, whenever he's completing the requisite
After
number of attendance.
completing the requisite attendance, she is entitled to. I am making that statement myself.
Tomorrow we'll pass the order, gathering the facts.
Please, Your Lordship.
Tomorrow at 11.
Please.
11.
Lordship.
Where is the interim order?
I,
Pass over.
Your Lordship would excuse me, this is my copy, it's highlighted.
Doesn't matter. Good, it is highlighted. So grace marks were claimed in second MBBS.
Please,
First MBBS.
first MBBS.
First MBBS.
Please,
Then you
Of the
failed.
2 months.
So you failed that elementary or what?
Please, I failed the year because 2 marks aggregate I fell short.
You failed the year.
I failed the year, but in the supplementaries I passed and that I placed before Your Lordship.
By virtue of interim order.
By virtue of the exam
first
taken.
year examination failure was under challenge, saying that you have to give me the grace marks in terms of the earlier regulations.
That was rejected.
Which the learned single judge said you are under a new regime, you are not entitled to. Against that, lords, this appeal has been filed. During the pendency of this appeal
Not
and
appeal.
pendency of the writ petition,
Petition.
she took a subsequent examination
That is what is.
voluntarily and she has passed. So therefore, she doesn't want to pursue this.
Not-
writ appeal.
That is a
Not
new regime
volunteer-
or new regime.
Voluntarily pursuant to the directions of this honorable court. Interim order was granted
In fact,
permission.
the entire earlier controversy is washed out.
Over now. my
It
lords.
may not
She wants
survive.
a new cause of action of her attendance, benefit of attendance under the interim order.
The results were declared during the interregnum.
Tomorrow you just.
Please, Your Lordship.
So that we will not commit any factual mistake,
Please, Your Lordship.
technical mistake in passing. At 11 will declare.
Done.
Lordships on submission, Lordships. Lordships.
But in September, you are going to complete your attendance or not?
I will.
September
Like-
25.
Ah,
September 25,
25.
if she were to attend regular classes, she will have 80% attendance. So therefore, she would be entitled by law, not pursuant to any order to be made. Because the writ cause has spent out itself. She has passed subsequently. The challenge to her rejection of writ petition also becomes infructuous academic.
The fourth respondent, Your Lordship, has been served and they've entered appearance. The college. Second respondent.
Give the appearance. Appear.
The college only says she has shortage of attendance. The list is between the university and the student about not granting him the grace marks.
Number 114. Mr. Madhusudan Adigabu.
I didn't see you on the.
Appear for the petition.
Turning around.
Lordship has time. Will take some time.
Any other day, my lord, we understand. It's not so urgent here. Any other day, if my lords are at the end of the day, we'll come back another day.
Who appears for the Wakaf?
But I appear for the one.
No, they are a very neutral role. It is declared to be a monument or not?
Yes, not 1951.
It is already declared.
Yes, it is declared as that,
Lord,
under
it
the
was-
1951 Act.
This was a
The
monument.
archaeological survey, we originally had a 1904 Act, then 1951. Then after the state reorganization, the latest one is
Any-
1958.
Any declaration is there?
Yes, there is a
There's
notification
no
which we have
section
produced.
4 declaration. There's a deeming provision under the new act, which says, if under the old act of 1904, if there were something declared as ancient monument, they will continue to be. The issue here is not of the declaration. It is an ancient monument. It is also a waqf. Question is, who can maintain? Under the Archaeological Act, my lord, unless and until the central government or the authority under the act either enters into an agreement with any of the monument owner and then takes over the management or maintenance, then only they come into the picture.
I
Otherwise-
dispute that position.
Otherwise, they are only to make a regulatory authority to see whether there are any violations. In this case, my lord, sum and substance, their very own website and the Press Bureau of India says this to be a waqf. And there is a notification under the Waqf Act of 1954 pursuant to a survey by the state government. And this 1954 Waqf Act also is a central legislation. (1954) Waqf Act also is a central legislation. And under that, there is a survey that is conducted and there is a notification which is produced.
So you don't dispute that it is a monument
Lord, Lord,
deemed to be continued
it
under
will
the.
continue as a deemed continuance. What we
No, the
dispute is,
declaration is dated 29th November 1951. 3 years before the Waqf Act was even enacted.
thereafter it became a waqf. So which one should prevail, whether the Waqf Act, central government,
No,
central
it-
enactment?
The
No, once it is a protected monument in 1951.
1915 protected monument.
29th November 1951 is the date on which the declaration, it was notified
Oh, then,
as a protected monument.
so it continues under the new act also.
Yes.
By
Yes,
virtue of
yes, yes,
which,
yes.
by virtue of
And
Section
as
3.
Archaeological Survey of India would be in the
Section 3.
custodian.
section 3.
Section 3,
Lord,
under section 4, they have again powers to notify.
Lord, the
They
moment.
did not choose to notify
They have
this.
not notified.
They did not. That's what I'm trying to say. Section 4, no notification.
Not
This is the
necessary.
new,
It
new act of
continues.
which
That's
year?
a new act,
Of which year?
1958, after the independence, my lord.
Lord, all declarations made previously will continue.
I'm
I'll-
supporting myself. There's a deeming provision.
Ancient
The
monument.
question here is whether there is any violation under the ASI Act at all. And our humble submission is there is no violation. Lord, let the petitioner say, Lord, petitioner, whether it is maintainable at all. He is a person who is not even connected to that area. He is neither an interested person. He doesn't live anywhere in the vicinity.
No, Lord,
He
no,
just picks up
no,
one.
once, Lord, notice is issued, we have taken a stand. Lord,
No,
we have filed an affidavit.
Yeah, that's all.
As Archaeological
This is
Survey of India.
notice.
I'm sorry.
Notice is notice.
I can take preliminary
No, no, originally
objection.
notice was issued, we were put on notice, we have come on record. We have filed an affidavit, we have produced documents.
That's okay, Lord. I can raise a preliminary objection with regard to the locus of the petitioner.
I
As-
thought that they are implemented straight away.
They were implemented only recently. And
No,
Lord, my submission would be,
you are right, notice. is-
after 1951, my lord, as Archaeological Survey of India, we become the custodian. Nobody can enter without our written permission.
But such a thing is not there.
We have not
You will
granted
argue
permission
that,
to anybody, including the newly implicated eighth respondent.
Then we'll have to be heard, my lord. My
That-
learned friend
that-
is
that I will
assuming a power which is not there under the act. Let the petitioner address his arguments, my lord. What is his interest? And if that is so, wherever there are violations, all monuments should be included in this writ petition. PIL, it is a PIL. Not pick and choose one person. And the state and the central government should work in conformity with the state government law, not make a statement contrary to this.
But I'll make a statement which is consistent with the provisions of the Ancient Monuments Act.
Section 3 is independent of section 4.
Please, my
Yes.
lord, I am not saying
So it
that
will deem to be
Yes.
it is a
Section 4 is very
deemed, only they will get a regulatory rights.
correct.
Regulatory right is to see if there is any violation.
So that is what they want.
No, there is no violation. Petitioner should say what is our violation. Somebody should tell us what is our violation. There's a madrasa going on. But
We
he
have-
can't
we
say
have-
he's a respect.
In our response,
He
Lord,
has- no,
on
they-
notice, my lord, your lordship wanted us to take a stand. We have taken a stand.
They have taken
Lord,
a
pursuant to
stand
the
that
court
we kept
notice-
quiet for all these years. Now we suddenly feel that's so. Why they kept quiet for 75 years, my lord, when
My lord,
this is-
they have constructed partitions they have made, they're residing in it, they constructed toilets, kitchens.
That pleading is not part of your pleading.
Yes, my lord, that is not permitted under the SI Act.
No, no, it is not part of your pleading that they have constructed toilets.
It's part of my pleadings, my lord.
Let us see. You're only saying that particular kind of activity is going on.
No, no, my lord, they are I had stated, my lord.
Petition.
Namely madrasa. That is the only government,
No, no, my lord,
subject to your correcting.
facts of the case.
He refers to some kitchen and other items.
prayer A, my lords.
Paragraph 11, page 14, my lord.
My lord, above that, my lord may see the status of the petitioner in paragraph 5.
No, one by one we'll go, my lord. I'll come to the status next. Let us go. Paragraph 11, my lord. If your lordship permits, I'll read it out.
And he says he just happened to enter into this and he noticed
Yes,
that there were some madrasa going on.
he's actually a tourist.
He's a tourist who just enters, according to him. Now he wants
No.
to save, he should save all monuments where, my lord, if there are any violations.
No
he
other
can't-
monuments or things are happening. It's only in this monument that is happening.
My lord,
If
that
it is
is
there,
a
let
very,
her point
very-
out. Yeah, I
very
will file a
sweeping
petition.
Show the government.
What, my?
Show your pleading.
Paragraph 11, my lord.
11.
Paragraph 11, page 14. I will read it out, my lord.
You filed your reply?
Lord, we have filed our reply.
Filed?
I've given him a copy.
Yes, yes. Where is that?
Please, my lord.
So you accept the status of national monument of this particular, what
Yes,
is?
my lord. All we say is, my lord, I'll just run through my statement of objection.
It is a temple, masjid.
No,
It's a mosque.
it's a mosque, my lord.
It's a
My
mosque.
only submission is, my lord, only submission is that it is a mosque, living monument. They are entitled to pray. Let them pray. Absolutely none can object it. Only thing is, they cannot reside, cook food, make constructions, alterations, bathing, toilets, all those things which are 50 students. That they cannot do. They can visit and do it. There is a gate even today, my lord. ASI people have put their watchman. He locks it at 5 o'clock, opens it and lets the visitors at particular hours. Photography is prohibited. It's under the control of the ASI. So they are entitled. Let them pray 5 times. Absolutely, I am not objecting on that, madam. They have to pray. It is their right. None can prevent that. Only thing is they cannot run a residential school in that premises. It's a protected monument, and they have done constructions also. That is all my submission, my lord. And there is no Hindu-Muslim issue as such. They are telling you there is absolutely no Hindu. It's a protected monument. It should be used as a protected monument, and they should pray. Surprising, they are not praying in that. Only the residential school is going on. For prayer, they are going to an adjacent mosque.
But the matter requires hearing, Lord. Your Lordship may fix a date.
We'll hear, not concluding it.
Yes. Let the state also file its reply, my lord.
Very well, I will.
The state has not filed its reply because there is a state archaeological act also.
That is not there. Please see the prayer of the petitioner.
So you have not filed 2 sets of your objection.
We have not filed, the state also has not filed. We will. What is it? What is it?
Your lordship may kindly go to the objections filed by the ASI.
We can file one more. There's no.
Yeah, the objection.
It is there.
Objections filed by the ASI, my lord. They have produced the photographs. I cannot produce photographs because photography is prohibited. They have produced the photograph wherein all my allegations are corroborated. The internal constructions, the bathing, toilets, the number of people residing there, all is corroborated. The people residing. My only submission, they have not tried to confuse the issue. I'm not objecting to their prayers. They have to pray. It is theirs. Let them continue to pray. The only thing, a residential school cannot be run there. That is all my submission, my lord.
So according to you, some objectionable activity is going on?
Yes.
What objection?
In violation of Rule 8, my lord, in my affidavit, I've extracted the rules, the relevant rules. Please, would your lordship turn to page 7 of my affidavit. I have filed a counter affidavit on behalf of respondent 1 to 5.
Yes.
My lord, page 7, para 15. I state that as per the Ancient Monuments Act,
Paragraph?
para 15, page 7. There are about 4 relevant provisions which I have extracted there. Section 5(6) states that the acquisition of rights in a protected monument shall not affect the use of any protected monument for customary religious observances. 16(1) states that the protected monument maintained by the central government, which is a place of worship or sign, shall not be used for any purpose inconsistent with its character. And 7 and 8 are relevant. Rule 7 of the Ancient Monument, Archaeological Sites and Remains Rules states that no protected monument shall be used for the purpose of holding any meeting, reception, party, conference, or entertainment except under and in accordance with a permission granted by the central government. Nothing in Sub-Rule 1 shall apply to any meeting, reception, party, conference, or entertainment which is held in pursuance of a recognized religious usage or custom. Rule 8 of the ancient so-and-so rules are certain acts are prohibited within the monument. The specified prohibitions are: A, do any act which causes or is likely to cause damage or injury to any part of the monument, or discharge any firearms, or cook, that is very important, or consume food, except in areas, if any, permitted to be used for that purpose, hawk or sell any goods or wares, or canvass any custom for such goods or wares, or display any advertisement in any form, or show a visitor around, or take his photograph for monetary consideration, except under the authority of, or under and in accordance with the conditions of a license granted by an archaeological officer, beg for alms, violate any practice, usage, or custom.
So none of the activities are going.
The cooking, Lord, the cooking, and then there are changes also, Lord. There are certain changes which have been carried out. Some new constructions have taken place, but which have distorted the original character of that protected monument.
Lord, what is notified is only a masjid, Jummah masjid.
No, Lord, my learned friend should wait. Lord, when your lordship asked me a question, let me complete. I
Now,
think lordships have agreed to hear this matter.
16(1) says that the protected monument maintained by the central
This
government.
is not maintained by them because there's no agreement for maintenance.
No.
Let me ask. Section 16(1) says that the protected monument maintained by the central government, which says it's a place of worship or shrine, shall not be used for any purpose inconsistent with
character. So therefore, our stand on this.
So religious preaching and the education is not inconsistent with.
Religious prayer is inconsistent. Religious prayer is consistent because it's a mosque. It is meant for prayer.
Preaching,
but other activity, my lord, running a school there, our pleaded position would be that it is inconsistent with the character, because there has to be a separate place for a school. Here there is no such place, and there is no place to reside. It should not have been used to reside. It should not have been used for the purpose of cooking, toilets, washing, bathing. These are all activities which would fall within the prohibited domain.
Is the mosque situated where?
This is in a place called Srirangapatna, near Mysore.
But their walkboard notification does not mention the word Srirangapatna, my lord. The word Srirangapatna is not at all mentioned in their notification. It says Ganjam. Ganjam is different from Srirangapatna.
But I produced some photographs, which would depict how exactly the protected monument is.
My lord, I pray for some time. My lord. I do have, my lord, 4 weeks, my lord, because this is.
No. 4 weeks.
My lord, slightly sensitive, my lord.
So you must file fast. No matter is sensitive here.
No, I know that, but I need some time, my lord, to apply. And
we don't have any sensitivity.
I apologize, my lord, for having used that.
There is a law which has to be implemented and enforced. We are doing that.
My lord, when you is all apart, when you will file within 2 weeks. We'll keep 19th December, 18th December.
Very
Send out to 18th December. While all the other respondents have filed their replies, the state government is yet to place on record its reply, which shall be filed before the next date, stand out to 18th.
Lord, the respondent 1 to 5, who are the
17th December.
respondent 1 to 5 would like to file a rejoinder to the objections filed by the Waqf Board.
You can file.
One submission, my lord. The notification of the Waqf Board does not mention the town's name Srirangapatna at all. It says Ganjam. Ganjam is totally different from Srirangapatna. That is one submission.
Ganjam is different from?
Srirangapatna. That is a different place. Srirangapatna is
We'll
a
answer
different
that.
place.
We'll answer.
So Ganjam is doing Ganjam.
Ganjam is a different village, my lord.
So they are running activity there.
No. There is notification mentions that name. It does not mention the name Srirangapatna.
Ah.
His disputed monument is at
Waqf notification.
notification. It says Ganjam. It does not say Srirangapatna.
So according to it, it's not a Waqf property.
Their notification says so. If going by their notification, it's not a Waqf property. That's one thing. Next date we will submit.
We'll hear it.
Much.
My lord, a person living in Kanakapura goes to Srirangapatna.
Lord, all such
On a
properties will have to be taken, my lord. All
And-
properties have to be taken. Can't pick and choose.
Yes, sir. Please give me a list. We will make it.
You have to say. You
Is the only
say
property
all-
where archaeological survey of the property being occupied, running a residential school and toilets, cooking is going on. There is no other such place. If it's there, let her give a list, or she should have filed it,
No,
or
he's
let
a
her give a list,
public
I will file
spirited
it. Madam.
person. Let him file an affidavit that every monument in the state is running as per rules.
Yes,
and
yes.
no
Why should I
violations.
file?
Let him file a statement.
You
of
show me where it is
affidavit.
violation, I will file the PI. Much of it.
He's come to court.
Yes,
All pending.
My lord,
Things-
we go beyond 17th, my lord.
we'll complete, my lord. We'll complete meetings.
Or in January, a date may be fixed. Whenever, my lord, I am ready. Let them file. Lord, we'll see on 17th, my lord, how what.
Yes, my lord, we'll see how it goes on the
We are
17th.
not in hurry, but let it be. Since it is fresh in our mind, that is. So फिर से लिखो ना, state government shall file reply before the next date. Other parties may also complete their pleadings before the next date. Stand out to 17th.
17th, very good.
We'll see whether to be taken up or not.
Yes.
When it
Great,
will be
great.
Obliged, my lord.
Serial number 13, which was reserved for judgment today morning. Respondents 2 to 10 were unserved. Comment advocate. Notice, they were respondents in the writ petition. But in the appeal, some of the respondents were arrayed as 2 to 10, my lord. They have no conflict insofar as the stand taken by the
like
appellant.
notice, notice,
My lordship, serial 81.
notice. इसमें notice कर दो.
Notice also
Payment,
can be
payment.
Can be dispensed also, my
We'll
lord.
file
Can't
memo.
take a stand contrary to the, it's a government's appeal. Can't take a stand contrary to that. Notice can be dispensed.
No, no, all must be served before we.
Will take notice.
You'll take notice.
Government has to take a notice, my lord. They are government agencies. Government has to take a notice, my lord. We have to take notice. It's a government's appeal, my lord. End of the day.
we take notice,
Very well. I'll take notice,
accept notice.
please.
Then we'll
It's
keep.
only a
it.
formality, my lord. in that.
Monday we'll keep them. All are served, he is accepting for all.
Rest of the respondents, my lord.
2
Monday,
to 10.
2 to 10.
Very well.
Then Monday. Monday. Monday.
Very well.
My lordship,
Notice returnable on Monday, learned advocate, learned
Please.
additional government advocate, Mr.
Harish. Harish.
Harish accepts notice on behalf of respondent 2 to 10.
my lordship, serial 81. There is an application against this. So it has been retained for 3 months. This is 5th time it is against office objection. Request my lordship to list for 2:30 for hearing.
What is the urgency?
Sorry, ma'am.
What is the urgency?
The urgency is that it is wrongly, listed for the fifth time against the office objection for the,
List it up
by the
within
third
10
part,
List it in the, get it listed.
230 matter. review.
Not on the board it will list.
Objection.